Good afternoon, everyone. I hope you all are well this afternoon.
Good afternoon, Your
Good
Honor.
afternoon.
Let's
Good
see.
afternoon,
Where we get,
Good afternoon.
Ms. Bridgewater, do you have the SAP reset date for me?
Sure, it's May 14th.
Okay, very good. Thank you.
Mhm.
And let's see, I guess we are waiting until courtroom 2 gets on with us. So we'll get started, I guess, as soon as we have courtroom 2 with us. Someone has a question?
Good afternoon, Your Honor.
Yes, good afternoon, Officer Milton.
I am ready with attorney Attai client. And ladies, listen up. Miss Holland, Miss Jackson, Miss Malone, Lamorin, Manta, come on. Step it up.
She's trying to get in there before me, Your Honor.
Well, she's not trying to. She
I
did.
see she's running. She's trying. She did try.
I think she beat you, Officer Norris.
I did. I was in. I got in. I give them the opportunity, Your Honor, but they were too slow for Milton.
Milton, do your female.
But you're not as quick as those knickerbockers you like.
I know.
Position 13, Miss Holland, come on up and have a seat.
Yes, good afternoon, Ms. Hollins. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video this afternoon?
Yes.
Thank you. Ms. Hollins, you've been charged in case 24 CR 002424G with disorderly conduct and willful obstruction of a law enforcement officer. Is there a history?
What number is this?
This is position number 13, Mr. Howard.
All right, hold on. I have to get this volume going. Hold on. Can you hear me?
I can hear you.
Islands. We got. I got 31 total. Ag assault from 2023, terrorist threats as well, and trespass. That's 23 SC 191021. I'm on probation for that. I'm on probation for identity theft fraud as well. That's out of Cobb County. 2021 probation, 2021 obstruction. 2019 probation, 2020 probation. 2019 battery DV. I'm sorry, battery conviction. 2019 simple battery no low. You want me to keep going?
I think you're good. Thank you, Mr. Howard.
Oh, and got a one out of Cherokee County. I'll tell you that.
Thank you. Good afternoon, Ms. Falk.
Yes, good afternoon, Your Honor. So this incident happened on the 27th at 1955 Dunlap Avenue in East Point. Officers arrived at that location and made contact with the defendant, whose sister was receiving some medical treatment. While on the scene, the defendant was acting aggressively toward her brother-in-law, who's the victim in this case, Mr. Timothy Kelly. The defendant told the victim he was through and that it was a wrap for him upon her return. She also began yelling and scuffling with a neighbor and was additionally walking back and forth over her sisters while the EMTs were trying to work to assist her sister in a medical emergency. When the officers asked her to step away from her sister because they were trying to assist her sister in a medical emergency, she refused to follow the commands from the officers. When they began to initiate arrest because of all of the disruption, she balled up her fist, held them close to her person to avoid handcuffs, began kicking and screaming and falling to the ground. She then refused to sit up in the vehicle and resisted being placed into the back seat. As you've already heard, this defendant has a lengthy history for obstruction, aggravated assault, terroristic threats, battery in 2019. The aggravated assault, terroristic threats was in 2023, obstruction in 2020, 2021, simple battery as well, and obstruction in 2020 and simple battery. Finally, there are probation violations from 2014, 2015, 2018, 2019, and 2021. So we are asking for a $1,500 surety bond. That's going to be $1,000 on the disorderly conduct, $500 on the obstruction. No further contact with Timothy Kelly. Stay away from 1955 Dunlap Avenue in East Point. No alcohol, drugs, and weapons. We'd also ask for one-day anger awareness. That's all, Your Honor. And we would like to sound for Mr. Timothy Kelly at this time.
So if that wishes to address the court, now is your opportunity to do so. Young lady, the young ma'am who's on the Samsung SM, I need for you to take the gum out or whatever you're eating to take it out. This is an official court proceeding. The Samsung ma'am in the black and white striped outfit. Can you hear me? Thank you. Mr. Ty?
Yes, Your Honor, my client is 33 years old. She has lived in Georgia most of her life. She is gainfully employed. She has a 4-year-old daughter. She does deny the allegations as stated in the warrant. As you heard, the police were called to save the life of her sister who had attempted suicide. She was unconscious. My client states that she was giving her CPR when the police arrived before the paramedics, Your Honor. They forced her to get away from her sister and stop CPR and waited for minutes there, just standing over her sister who was unconscious. The police didn't perform any life-saving measures. She states that they just stood over her for several minutes until the paramedics arrived. Again, she does deny the allegations. I know she has some history, but I don't believe that that's a reason to be arrested in a scenario like this when she was trying to save her sister's life. And of course, hysterical and frustrated that she wasn't able to continue giving CPR until the paramedics arrived and nobody did anything. I would ask for a signature bond through the jail in this case, Your Honor. I would object to a stay away and no further contact. This is her home. She lives there with her child. I don't know how her sister's doing, but I wasn't able to get in touch with the complaining witness, Timothy Kelly, but she states that the police were only called to come and save her sister's life. And I would hate for her to, not have a place to stay because of this.
I'm sorry, Tim Kelly, does he live at that residence?
Yeah, she states that they live on the upstairs floor and she lives downstairs. But of course, he may be in the hospital with his wife, but I wasn't able to get a hold of him. But she states that it's absolutely false that he feels like a victim in any way. And I do think that the facts as stated in the warrant would justify that he's not afraid of her and there was no threat to him at all.
Your Honor, I'd object to this contention. She has no information based in that. She has not spoken to the victim, Mr. Kelly. She has not gotten his understanding. She's essentially making conjecture and assumptions based upon the warrants.
Have you spoken with the complaining witness?
No, but you haven't either. So why I'm asking for a stay away, I didn't attempt to implicate the victim was not afraid of this person. I asked for a stay away and no further contact, and you have nothing to contradict that.
Well, I haven't been able to speak with him. I would contradict it because I don't think that somebody should have to stay away from their home or not have contact with her brother-in-law because she said this is through and it's a wrap. Those aren't threats. It's not something that would place somebody in fear or make somebody want to not have any contact or be afraid of another person.
The police disagree with you because they took out a warrant for disorder.
Well, the police arrested somebody who was trying to save her sister's life.
So it's going to be $1,000 signature bond through the jail on each count, total of a $2,000 signature bond through the jail. At this point in time, since no one's talked to the alleged victim, it'll be a no further contact and to stay away. If somebody does talk with him, I'm happy to modify that, Mr. Ty, if you get in touch with somebody. No drugs, alcohol, weapons while out on bond. Maybe you can do that. And it's my understanding that she has a hold, so she'll be released to the hold. And if you get any information prior to at any time subsequent, Mr. Ty, just let me know and we will consider modification, okay?
Thank you, Your Honor.
All right, very good. Good luck to you, Ms. Hollins.
Thank you.
You're welcome.
Position 14, Ms. Christian Jackson.
And let me just, since we have so many people this afternoon, courtroom 2, I'll have you all listen in also. Let's see, you have a good afternoon, everyone. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We have provided to you this afternoon the help of the public defender's office if you so seek to utilize their services. We are doing this by video this afternoon. If anyone objects to having their case heard by video, please let me know when you come before me. And let's see, this is Ms. Jackson, is that correct?
Yes, Your Honor, position 14, 1-4.
Yes. Thank you. Ms. Jackson, you've been charged in case 24 CR 002419G with simple battery family violence. Is there a history, Mr. Howard?
What the rest? 2018 probation, 2018 simple assault conviction, 2017 simple battery DV conviction.
Yes, Ms. Falk.
Excuse me, Your Honor, which position is this?
This is position 14.
14, Christian Jackson. Okay, just wanted to make sure I was on the right page. All right, so this incident happened at 3000 Stone Hogan Connector Southwest in Atlanta. The incident took place at Greenbrier Commons apartment located at 3000 Stone Hogan Connector in Atlanta, Georgia. The defendant threw bottles and struck the victim, Miss Lamar Ridley, in the mouth. The two lived together at the incident location. The defendant has previous convictions for simple battery family violence in 2017, simple assault in 2018, and a dismissed cruelty to children arrest in 2017, and a null prost terroristic threat simple battery in 2018, as well as a probation violation in 2018. State's recommendation is a $3,000 surety bond, no further contact with Lamar Ridley, stay away from Greenbrier Commons apartments located at 3000 Stone Hogan Connector in Atlanta, Georgia. We're also recommending family violence intervention program due to the 3 cycles that include family violence and simple assault, as well as no alcohol, drugs, or weapons. That's all for the state.
Mr. Lamar Ridley's on the line and wishes to address the court. Now is your opportunity to do so. Doesn't appear so. Yes, Ms. Atai.
Yes, Your Honor. My client is 25 years old. She has lived in Georgia all her life. She states that the complaining witness does not live at the address 3000 Stone Hogan Connector. The phone number that's listed on the citation is a wrong number, so I wasn't able to get in touch with the complaining witness. Her history is from at least 6 years ago or more. She is a high school graduate. She's gainfully employed as a shift lead at UPS. She also suffers from sickle cell and is disabled, Your Honor. I think she's recommended for a UJR level 1. I think a $3,000 surety bond is beyond what she can afford and beyond what's necessary in this case. I would ask for a signature bond through the jail, and no further contact is fine. But the stay away, I would ask for a one-time law enforcement escort to confirm that the complaining witness does not live at this address. And I would object to the FVIP.
It will be a $5,000 signature bond through pretrial per judge if necessary, level 2. No further contact with Lamar Ridley. She can have a one-time escort to the 3000 Stone Hogan address. If Mr. Ridley is there, she necessarily cannot be there and must gather her belongings and find someplace else to go. If he is not living at that address, then she, of course, can stay there. No drugs, alcohol, weapons while out on bond. One-day anger awareness also. Good luck to you, Ms. Jackson.
Next is position 22, Samantha Lamorin.
Good afternoon, Ms. Lamorin. You've been charged in case 24 CR 002401F with battery family violence. Is there a history, Mr. Howard?
Second arrest, 2022 simple battery, 2 counts, 1 count battery dismissed.
Good afternoon, Mr. Graham.
Good afternoon, Your Honor. This incident took place on April 26, 2024. Law enforcement responded to a domestic dispute at 1737 Center Avenue in East Point. Upon arrival, Janae Cadet advised that her sister, Samantha Lamorin, pepper sprayed her during a dispute over the washing machine. Ms. Cadet sustained injuries to her eyes, including redness and swelling. Our office has been unable to reach Ms. Cadet at this time, Your Honor. Based on the history, the state is recommending a signature bond through pretrial services, a one-day anger awareness course, no further contact with Janae Cadet, stay away from 1737 Center Avenue, no alcohol, drugs, or weapons. And of course, we'd like to sound for Ms. Cadet at this time, Your Honor, in accordance with Marx's law.
Hey, Cadet is on the line and wishes to address the court. Now is your opportunity to do so. Mr. Ty?
Yes, Your Honor, my client is 28 years old. She has lived in Georgia for most of her life. She is gainfully employed at Complete Care at Home in their HR department. She states that the complaining witness was the first aggressor and she used the pepper spray in self-defense. She denies that she was the primary aggressor, Your Honor. She has graduated high school. She attended Kennesaw State University and attends Chattahoochee Tech right now. I was not able to get in touch with the complaining witness, but she does tell me that the complaining witness is moving out of the house. She and her sister live there together, but she states that her sister had planned to move out today, April 29th. I would ask for a one-time law enforcement escort to confirm that her sister has moved out. She's recommended for a signature bond through the jail, Your Honor. So I'd ask for that signature bond through the jail. No further contact is fine. Nothing further.
Okay, it'll be a $2,000 signature bond through pretrial level 1, one-day anger awareness, no further contact with Ms. Cadet. She can go back to the Center Avenue address on one occasion with law enforcement. If Ms. Cadet is not living there, she can remain there. If Ms. Cadet is there, she has to gather her belongings and find somewhere else to stay. No drugs, alcohol, weapons while out on bond. Good luck, ma'am.
Next, we have position 23, Ms. Mansell.
Good afternoon, Ms. Mansell. You've been charged in case 24 CR 002393F with simple battery family violence. Is there a history, Mr. Howard?
First, she got ag assault charges in Superior Court. I don't know what the bond is. I'll go check though.
Thank you, Mr. Howard. Your Honor, if I may start while Mr. Howard is.
Yes, thank you.
Okay. This incident happened on April 26th at 3930 Kenner Drive Southwest in Atlanta. The defendant pepper sprayed her grandmother, Ellen Jackson, during an argument about not taking out the trash. Ms. Jackson stated the defendant entered her room and pushed over an ironing board, and due to past experiences that Ms. Jackson has had with her granddaughter, she armed herself with a mini bat for her protection. The defendant then pepper sprayed her grandmother. The defendant claimed that her grandmother tried to barge in her room and stated that's why she pepper sprayed her, which is contradictory to what the grandmother said. Apparently, the defendant is currently in custody for multiple counts of aggravated assault, which was from pepper spraying other members of her family in November of 2023. So this is actually not the first time she's employed pepper spray as a weapon, allegedly. We have had an opportunity to speak with the grandmother, Miss Ellen Jackson, and we would like to sound for her at the conclusion of this. They do live together at the incident location, and she did confirm the events in the warrant. She stated this has never happened before, which, again, it may have never happened to Miss Jackson before, but in November of 2023, it did happen to other individuals, which include some cruelty to children charges in there as well. She stated she is not in fear of the defendant and wants continued contact. However, given these circumstances, we are asking for a $3,000 surety bond, family violence intervention program due to the other allegations. Stay away from 3930 Kenner Drive Southwest in Atlanta. No alcohol, drugs, or weapons, and no further contact with Miss Ellen Jackson. We would at this time like to sound for Miss Ellen Jackson.
Ms. Jackson is on the line and wishes to address the court now. So doesn't appear so. Ms. Atai.
Yes, Your Honor, my client is 24 years old. She is the mother of one 2-year-old son. She is gainfully employed as a security officer. I did speak with this is her first arrest, Your Honor. I spoke with the complaining witness, her grandmother, and her grandmother told me that she has raised her grandchildren this grandchild since she was 11 years old when their mother passed away from breast cancer. She stated that my client has nowhere else to go. This is her first time ever being in trouble. She stated at least 10 times to me that she's not afraid of her and that she wants her to come back to the home. Your Honor, this is her first arrest. She did have to pay over $20,000 of bond for the felony charges. She doesn't have any more money to pay for a bond in this case, and it's her first arrest. I would ask for a signature bond, and I would ask for that through pretrial services. I don't object to the FVIP. I object to the no further contact. Her grandma has stated that she does want contact with her, so I'd ask for no violent contact, and I would object to a stay away.
It will be a $2,000 signature bond through pretrial level 1, no further violent contact with Ms. Jackson, FVIP, and no drugs, alcohol, weapons while out on bond. Good luck to you, ma'am. Do we have Mr. Attorney Render's client, Devon Williams?
Yes, thank you, Judge.
Your Honor, I was waiting for an add-on calendar for him. Apparently, he wasn't on the first calendar.
Okay, I haven't gotten an add-on calendar myself, so Mr. Render, Attorney Render, will be with you as soon as I can. Okay.
Thank you, Judge.
You're welcome. Who do we have next?
And then we're going to go to position number 3, Ms. Katie Backus.
Your Honor, really quickly on Mansell, what was the level on that pretrial services?
Level 1.
Okay. And I do have some additional information on the other case that we addressed, Miss Johnson.
Okay.
We did actually have an opportunity to speak with the victim in that case. And the information we received, hold on, let me just pull up my victim notes, is that he confirmed the events in the warrant, stated the defendant did threaten him. He would like a no further contact and a stay away from 1955 Dunlap Avenue, apartment 6, MHE, ADET, and anger management. That was the request of our victim, Mr. Kelly.
Tell me who we're talking about, what position, Ms. Falk, I'm sorry.
Oh, it was, I believe last name was Hollins. Let me just double check.
Position 13.
Yes.
Okay. And
Quinetta Hollins, the disorderly conduct and willful obstruction.
I believe that I ordered no further contact, did I not?
Yes, you did. I was just confirming that we did have an opportunity to speak with the victim and he does want no further contact and a stay away.
Okay, all right,
What
thank
is
you.
that stay away address again?
1955 Dunlap Avenue in East Point.
Thank you.
Thank you.
Okay, tell me again who we have next.
Position number 3.
Okay, thank you. Ms. Backus, you've been charged in case 24 CR 002422Y with battery family violence. Is there a history, Mr. Howard?
Nope.
Ms. Falk?
Yes, Your Honor. Let me just check something really quickly. I'm juggling 2 different calendars at the moment, so.
Okay, fine.
Let's see. Okay. So. Okay, so what I have on this defendant is that this incident happened on April 28th of 2024. And on that date, it appears that the defendant made contact with sorry, I'm pulled it up and I'm getting different information. Okay, that the defendant on that date made contact with Daniel DePaula by throwing 2 cups of coffee on him and hitting him in the face with her hand. That caused his right eye to be bloodshot red, as well as throwing a garbage bag at the right side of his head. The 2 of them are husband and wife, and this incident stemmed from apparently them having an argument that escalated because she forgot her credit card and couldn't pay for coffee, which he stated they got into an argument about, and it escalated to that point. The state would ask for a signature bond through pretrial services, given this is the first offense. We would also request no further violent contact with the victim in this case, which is Daniel DePaula, as well as a 1-day anger awareness and no alcohol, drugs, or weapons. We would like to sound for Mr. Daniel DePaula at this time.
Mr. DePaula is on the line and wishes to address the court. Now is your opportunity to do so. Okay, who's representing Ms. Backus?
You
Kim?
believe that is me, Your Honor.
Okay,
Ms. Backus is actually 36 years old, and I believe that she is qualified for signature on bond. This is her first arrest ever. Your Honor, she is gainfully employed as a massage therapist. They do not have any child together, and I try to reach Mr. Husband. I believe his name is Daniel DePaula, but I couldn't contact him yet. I hope he's here to testify that he is not afraid of my client. We would like to request for no further violent contact. And she has a vocational school. She's been here in Georgia for the last 5 years. I think she deserves to have a signature on bond through jail. I mean, pre-trial, Your Honor.
And Your Honor, I would say that we did have contact with the victim. He stated his eye is fine. He did not have to seek medical attention, and he's not in fear and wants to continue contact, which is why our recommendation was as we have stated.
$3,000 signature bond through pre-trial level 1, 1-day anger awareness, no further violent contact with Mr. DePaula, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
Thank you very much, Your Honor.
Welcome.
Your Honor, you broke up. Can you repeat that bond amount?
3,000 signature bond through pretrial level 1, 1-day anger awareness, no further violent contact with the alleged victim, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Who do we have next?
Number 25.
Good afternoon, Mr. Neely. You've been charged in case 24 CR 002420Y with battery family violence. Is there a history, Mr. Howard?
What's the name again?
This is Mr. Justin Neely, position 25.
I got first arrest.
Okay, Ms. Falk.
Yes, Your Honor. Right. All right, this incident happened April 25th of 2024 at 3585 North Commerce Drive in East Point, Georgia. At that location, which is BJ's, a restaurant, the defendant and Aaliyah Hawkins got into a verbal altercation. The altercation turned physical when the defendant placed the victim in a headlock and dragged her. The defendant then pulled Ms. Hawkins by her hair, struck her multiple times about the face with an open hand before fleeing the area. The responding officer did observe swelling under Ms. Hawkins' eye and a laceration to her chest, which she sustained as a result of the incident. I will also state that the victim in this case is 17 years old and is a minor. So for that reason, the state's recommendation is a $2,000 surety bond, no further contact with Miss Aaliyah Hawkins, stay away from the BJ's restaurant at 3585 North Commerce Drive in East Point. We are also recommending 1-day anger awareness and no alcohol, drugs, or weapons. That's all for the state.
Ms. Hawkins is on the line, wishes to address the court. Now is your opportunity to do so. Mr. Ty.
I believe I saw her on the call, Your Honor, but my client is 18 years old. He has lived in Georgia for 14 years, Your Honor. This is his very first arrest. He's gainfully employed as a security guard with lifeguard security. The complaining witness, I spoke with the complaining witness. She stated she would be on the call. She stated that she does want contact with him. Stay away from the incident location is fine because it's the BJ's. I think that they live together though, so I would object to no further contact with the complaining witness. She stated that she does want contact with him.
Okay, say hi, good morning.
Miss Aaliyah, I see you there. If you'll just hold on for me for a minute, I'll be with you, ma'am. But let Mr. Ty complete speaking with me.
Thank you, Your Honor. So again, I would ask for no violent contact with the complaining witness, and I would ask for a signature bond through the jail, Your Honor. And this is also a Riverside issue. He was arrested at that time on April 25th at 11 a.m. or around 11 a.m. So I'd ask for a signature bond through the jail. Nothing further.
Miss Hawkins, if you'd like to speak with the court, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell the court?
That didn't happen, and I'm okay with being around him, and we can have further contact, no more violence.
Okay, well, if it didn't happen, then why are you asking?
It didn't
for more
happen like
violence?
that, the way it was explained.
Has there been violence in the past?
No, sir.
Okay. Do you live together?
Yes.
All right. Are you afraid of him?
No, sir.
Okay. Thank you for being here this afternoon, Ms. Hawkins. Anything further?
Judge Morrow, I will say, oh, sorry. I didn't know if you were talking to the attorneys or Ms. Hawkins. My apologies.
No problem. And I was speaking with anyone. So go ahead, Ms. Falk.
So what I will say is that it does look like Miss PD Atai is right. This incident happened. The arrest date is stating April 25th at 11:40 p.m. I am wondering, because that was Thursday night, why he did not appear on Friday's calendar. So this wasn't a issue of not having SEA on Saturday. He should have appeared on Saturday's calendar, but it doesn't look like he was booked in until today at 3:48 a.m.
Okay. It'll be a $3,000 signature bond through pretrial level 1 day anger awareness, no further violent contact with Ms. Hawkins, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Neely. You also, Ms. Hawkins.
He 18, he need a cosign.
Does he have someone that can co-sign for him, Mr. Ty?
Your Honor, I didn't see that he needed a co-signer. He's independent. He works. He lives with his girlfriend. I don't have a co-signer. I don't have information for a co-signer.
Okay, it'll be a $3,000 signature bond through the jail, with the rest of the conditions.
Your Honor, would he have to pay for the 1 day anger awareness?
He can do that online.
Okay.
Next we have case number 18 through 21. Mr. Amari Lamb.
I don't know what they mean.
See, good afternoon, Mr. Land. You have been charged in case position 18, case 24 CR 002392C with theft by shoplifting. Position 19, case 24 CR 002414C, theft by shoplifting. Position 20, case 24 CR 002423C, theft by shoplifting. Position 21, case number 24 CR 002425C, theft by shoplifting. 2 counts. Is there a history, Mr. Howard?
14. 2020. You got a shoplifting conviction from this year. 2023 larceny in another state. 2021 shoplifting conviction. 2019 possession of a forged instrument conviction. 2018 harassment conviction. 2017 possession of a forged instrument conviction. 2014 and 13 FTA. We got holds out of the cab in Henry County.
Okay.
That's it.
Who's presenting for the state?
Tracy Mokaka here on behalf of the state, Your Honor. Good afternoon.
Yes, good afternoon, Ms. Makaki. I believe this is your first time appearing before me.
Yes, Your Honor.
Yes, good afternoon, ma'am. You can proceed.
Okay. Mr. Land has been arrested for shoplifting on 6 different occasions, 5 of which were misdemeanors, 1 of which is a felony shoplifting. All of these occurred between July 2023 through April 2024. Mr. Land is accused of stealing Lego sets from 5 different Target stores across the Atlanta area. Officers state that Mr. Land would go to the toy section, select Lego sets, then proceed to self-checkout where he would scan a Dove soap barcode, which was located on his phone, instead of scanning the Lego sets that he was actually obtaining. The amounts range from approximately $225 to $490.97. So he often gets pretty close to that felony amount, but doesn't quite cross that threshold. Again, he's accused of doing this at several Target locations across the county. There is no practical purpose for Mr. Land's behavior. He's not stealing baby formula or Lego sets each and every time. As was mentioned, he has a long history of fraud and theft. As recently as 3 days ago, he was convicted of shoplifting by becoming municipal court. Given Mr. Land's history of fraud and theft, we are recommending that he receive a $500 surety bond for each and every offense, making his total bond amount $2,500. We are also recommending that he take an anti-theft course and that he stay away from all Target locations. At this time, I would like to sound for Mr. Charles Bowling, who is the corporate victims attorney for Target stores.
Good afternoon, Mr. Bowling. Would you like to address the court?
Good afternoon, Your Honor. Can you hear me?
I can hear you, sir.
Hi, yes, I'm with Alto US. We are the corporate appointed victim for Target stores, Kroger stores, Walgreens, and select REIs here in Metro Atlanta. We would ask that the court takes the extensive history for Mr. Lawn in the state's recommendation for bond. We would like to for a stay away order from all Targets. We would also like to outline that there are two outstanding holds in the counties of DeKalb and Henry, and that this court take the consideration of monitoring Mr. Lawn if he is released on bond.
Okay, thank you, Mr. Bolin. Ms.
Thank you.
Kim, is this your
Yes,
this your
Your
client?
Honor. Yes,
Okay.
he is my client. Mr. Len is 29 years old, Your Honor, and he has been at Forsyth County for 1.5 months, more than 45 days at Forsyth County. I believe 3 days ago, he got conviction from coming municipal court at probably the same place, Forsyth County, where he was incarcerated for 1.5 months. And it has been more than 3 days. After that, he came over to, after he resolved issues at Forsyth County, he came to Fulton County. It has been more than 3 days, so it should be a Riverside issue. And also, Your Honor, please consider that he also has 2 outstanding holds. He's not going anywhere. He has a long way to go. We would like to request for a signature on bond through jail, so that way he can continue to take care of the other matters, Your Honor.
Ms. McCracken, is this a Riverside issue?
I believe so.
I understand you do, Ms. Kim. I'm asking the state.
Your Honor, I'm showing the arrest date and sorry to intervene, but since Ms. Makake is new, I just wanted to kind of address this. I'm showing the arrest date as April 27th, which was a Saturday at 10:38 a.m., which would mean Riverside would trigger, let's see, tomorrow at 10:30 a.m. So we disagree that this is a Riverside issue based on the time of arrest that is showing in the jail system. If PD Kim has something contrary to that, we would like to see it.
Anything further? Anything further, Ms. Kim?
I would like to look up Forsyth County and see if I can get any answer before the hearing gets over.
Okay, well, if you come back with anything to the contrary, I will I will take it up. But at this time, it's going to accept the state's recommendation of a $500 good bond per charge and a stay away from all Target stores. So position 18, $500 good, stay away. Position 19, $500 good, stay away. Position 20, $500 good, stay away. And 21, $500 good on both charges, which means $1,000 good total. Stay away, no drugs, alcohol, or weapons on all counts. Okay?
Thank you, Your Honor.
All right, good luck to you, Mr. Land.
Next, we will go to position number 28, Mr. Tyler Poole.
Good afternoon, Mr. Poole. You've been charged in case 24 CR 002421E with driving under the influence of alcohol less safe, possession of marijuana less than an ounce, possession and use of drug-related objects, and following too closely. Is there a history, Mr. Howard?
I don't have his South Carolina history, but he got 11 cycles out of Georgia. 2016 probation, 2016 possession of a Schedule 4 and DUI conviction, 2015 DUI conviction.
Graham?
That's it.
Thank you, Your Honor. This incident took place April 28, 2024. Tyler Poole rear-ended a vehicle driven by Jason Rickles that was on Mimosa Boulevard and Marietta Street. While speaking to Mr. Poole, the officer observed an odor of an alcoholic beverage coming from his person. His eyes appeared droopy, and he was swaying while standing. He did not consent to a field sobriety test or a breath test. He was placed under arrest at the scene. Search of the vehicle yielded marijuana in plastic bags, about 7.9 grams, and a glass bottle with burnt residue. Your Honor, based on the history, I found a few driving infractions, also 2015 DUI arrest, 2012 DUI arrest. The state is requesting a $3,500 surety bond. It's $2,000 on the DUI and $500 on each of the 3 remaining counts. Also an ADET, no driving, no alcohol, drugs, or weapons while out on bond.
Ms. Kim?
Yes, Your Honor, my client is 31 years old and he denies the allegation, Your Honor. He did not drink and he is gainfully employed at a food truck and he's been working really hard. He does not have any children. However, he is a sole provider for him and his family members. And we would like to request for a signature on bond for minor things except DUI. We do understand that DUI is not something that is, we cannot take it lightly. So we would like to request for a signature on bond through a pretrial. And yet we want to make sure that it's not too high. If it is, it has to be a bond. Even though he is gainfully employed, his financial situation is not really good at this point. That's about it, Your Honor. We would like to request for a signature on bond if possible.
Okay, for the DUI, it'd be a $2,000 good bond. Possession of marijuana, $500 good bond. Possession and use of drug-related objects, a $500 good bond. Following too closely, a $500 good bond. Makes for a total of a $3,500 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Poole.
Next, we go to position number 34, Mrs. Tyrone Watley.
Good afternoon. Good afternoon, Mr. Watley. Let's see, you've been charged in case 24 CR 002416G with theft by receiving stolen property. Is there a history, Mr. Howard?
18. He got like 5 burglary convictions. He's on probation for burglary. A couple of them. 2018 possession of tools conviction. Yeah, that's pretty much it.
Graham?
Thank you, Your Honor. This incident took place on April 28, 2024. Tyrone Watley was in possession of a multicolored Nike backpack that was stolen from the residence of Corey Woods during a burglary. The residence of that burglary was 1687 Campbellton Road, Southwest. Mr. Watley advised that he bought the backpack from an unknown person on the street for $5. We were unable to get in touch with Mr. Woods, Your Honor. And based on the history, the open burglaries, and the burglary probations, the state is recommending a $1,000 surety bond, Your Honor. No further contact with Cody Woods. Stay away from 1687 Campbellton Road. No alcohol, drugs, or weapons. And if we may sound for Mr. Woods, Your Honor, in accordance with Marcy's law.
Mr. Woods is on the line and wishes to address the court. Now is your opportunity to do so. Afternoon, Ms. McLeod. Is this your client?
It is, Your Honor. Good afternoon.
Okay. You can proceed.
Your Honor, my client tells me that he had this backpack which he bought from someone on the street. He said he was coming from a job that he was doing because he does landscaping and handyman work when someone accosted him with a gun and said, don't move, stay right here until the police comes, which of course he did because he didn't want to be shot. So he remained there, and I guess this person alleged to the police that my client had a bag which previously belonged to him. My client tells me that he did not know that the bag was stolen. He was just carrying it on his back because he had some other stuff in his hands. I would ask the court to consider giving my client a signature bond because he does not have any money to pay a bond based on what he tells me, Your Honor. Doesn't even have a telephone of his own at this point in time. Nothing further, Your Honor.
Okay, it'll be a $500 good bond. No further contact with Mr. Woods. Stay away from the Campbellton Road address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Watley.
Thank you, Your Honor.
Next, we can go to position number 1, Mr. James Alexander.
Good afternoon, Mr. Alexander. You've been charged in case 24 CR 002388Y with battery family violence. Is there a history, Mr. Howard?
Nope, first arrest.
Okay.
Your Honor, if we could also address Savannah Williams. I don't know if she's at Fulton ACDC, but if they could bring her forward as well, we could address both. They're cross defendants.
Okay.
And it looks like Miss Williams is coming up to be seated.
All right, good afternoon to you, Ms. Williams. You have been charged in case 24 CR 002389Y with simple battery family violence. Does Ms. Williams have a history, Mr. Howard?
No.
Okay. Ms. Falk?
Yes, Your Honor. So this happened at Millworks apartment at 1888 Emory Street Northwest in Atlanta on April 27th. Defendant Alexander advised that defendant Williams assaulted him. He stated he asked her to leave. She refused, slapped him several times. He tried to physically remove her, but she ran and grabbed a kitchen knife. And then he pursued her out of the apartment to get his keys. When defendant Williams was questioned, she said that she walked into the bedroom to retrieve her belongings, and it was defendant Alexander who initiated contact by forcefully shoving her. She did admit to striking him in kind of in protection of herself, and then he chased her, which caused her to according to Miss Williams, grab a knife in self-defense. Defendant Williams then stated she left the apartment. When she returned, defendant Alexander began screaming at her, chased her for a spare key that was around her neck, grabbed her by the hair and dragged her outside, grabbed her by her hair and dragged her outside, causing scratches to her left arm and hip. Since, given the circumstances and given the fact that neither one have any history, the state's recommendation is a $3,000 signature bond through pretrial services, 1 day of anger awareness, no further contact with one another. And for Miss Williams, because it does appear to be Mr. Alexander's residence, a stay away from 1888 Emory Street Northwest in Atlanta, and for both, no alcohol, drugs, or weapons. That's all for the state.
Mr. Cook, is Mr. Alexander your client?
Yes, Your Honor.
Okay.
We would have no objection except to the 1 day anger awareness. It is his location. It is his residence. He's the only one working and is the one paying rent. We do have obviously contrary stories here, so we would have no objection to the signature bond. We would ask that it be through the jail, and we would object to the 1 day anger awareness for my client.
McLeod, is Ms. Williams your client?
She is, Your Honor, and we object to the stay away. This is where my client lives. She tells me that both of their names are on the lease, Your Honor, and she also tells me that she doesn't have anywhere else that she can go to live. So we would definitely object to the stay away. She would prefer no further violent contact because, as I stated she has nowhere else to live and her name is on the list. It is true that she is not working at the moment, but she was working as recently as a month ago, Your Honor. She's in the process of seeking re-employment. We are okay with the signature bond, Your Honor.
And Your Honor, I would like to just point out that according to the police report that I read, the two of them are no longer in an intimate partnership. It is an estranged relationship. And so for that reason, as well as for the timing from the incident to today, I do have concerns that this will continue. And so that's why we're asking that one of them, and the police report indicated that he was the resident, but one of them, in the state's opinion, needs to be somewhere else.
My client tells me she has nowhere else to go. She also tells me that her name is also on the list. She states that both names are on the list.
Your Honor, it's my understanding that both names are on the lease. He doesn't have any place else to go either. But if she returns, I mean, he's the only one working. He's the only one who's going to be able to pay the rent. So if he's not there, I mean, the apartment will go away.
Okay. For Mr. Alexander, it's going to be a $2,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with Savannah Williams, and no drugs, alcohol, or weapons while out on bond. For position 35, Savannah Williams, it will be a $2,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with James Alexander, stay away from the Emory Street address. She can go back to that address on one occasion with law enforcement to retrieve any belongings, and no drugs, alcohol, or weapons while out on bond. Good luck to you both.
Thank you, Your Honor.
Thank
That
you.
concludes my business before the court today. May I be excused?
Yes, have a good afternoon, Ms. McLeod. Thank you.
Thank you, Your Honor.
Next, we can go to position number 4, Mr. Perry Banks.
Good afternoon, Mr. Banks. You've been charged in case 24 CR 002398J with battery. Is there a history, Mr. Howard?
Hold on. 17, 2014 battery DB, first offender. 2010 possession of marijuana. That's it.
Falk?
This happened April 27th, 2024 at 311 Scott Street, Southwest in Atlanta. In this incident, the defendant pushed Ms. Taylor Barker into a fight with 3 female juveniles, during which Ms. Barker was struck several times in the head and the face. Ms. Barker sustained a laceration to her lip and nose as a result of this incident, and several bystanders stated that the defendant is the one who caused the victim to fight the juveniles, which resulted in this incident. The state is asking for a $1,500 surety bond. We are asking for no further contact with Ms. Taylor Barker. Stay away from 311 Scott Street in Atlanta. We are asking for 1-day anger awareness as well, and no alcohol, drugs, or weapons. I do just want to look at one thing, which is the age of, let's see. It appears that Miss Banks is 60 years of age, is turning, 59 years of age. And the victim in this case, just to check on that as well, appears to be much younger. And so for that reason, we do have concerns about what occurred here and the fact that a grown woman is causing a bunch of juveniles to beat up a individual. And for that reason, that is why we are asking for the surety bond that we are asking for. We would at this time like to see if Miss Barker, Taylor Barker, is here and would like to speak. So if we could sound for Taylor Barker at this time.
Taylor Barker is on the line and wishes to address the court. Now is your opportunity to do so. So, Mr. Cook.
Oh, and sorry, Your Honor, the victim is 11 years old.
Taylor Barker.
Yes. So that
Okay.
is why we are asking for a surety bond in this instance. You have a woman who is 58 years old forcing an 11-year-old to fight other juveniles.
Mr. Cook.
Your Honor, my client is a male, not a woman. He denies the charges. He lives at 311 Scott Street, so we would object to any stay away. He's renting there. No further contact. He's more than happy for that to be put in place. We would be asking for a signature bond, and we would be objecting to any anger management force.
So, who is Taylor Barker to Mr. Banks? Do we know?
I think I think they're neighbors. That's all I know. I think they're neighbors.
Okay.
And Your Honor, I am not sure of the relationship between the parties.
Okay. It will be a $3,000 signature bond through pretrial level 1-day anger awareness, no further contact with Taylor Barker, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Banks.
Next, we will go to position number 5, Mr. Battle.
Good afternoon, Mr. Battle. You've been charged in case 24 CR 002400Y with battery family violence. Is there history, Mr. Howard?
$16 total, 2022, false report of a crime, simple battery, marijuana possession, not a Clayton County, that appears to be open. 2016 probation, 2015 marijuana, FTA, hindering emergency calls, simple battery DV NOLO, 2012 theft by receiving, giving false name conviction, 2012 battery possession of cocaine conviction.
Yes, Your Honor. As you heard, this defendant does have prior family violence battery, simple battery family violence, which he did plead NOLO to in 2015, as well as a false report of a crime and simple battery family violence from 2022. The defendant also has an FTA in 2015 and probation violations in 2015 and 2016. In this incident, this happened at 932 Natham Drive in Atlanta. Law enforcement was dispatched in reference to a domestic disturbance. They did speak with Miss Pamela Battle, who's the mother of the defendant, who stated that her son, the defendant, had struck her grandson, Justin Battle, in the face and head. The defendant, Miss Battle, got into an argument about the defendant's drinking, at which the defendant got loud with Miss Battle. The victim, Justin Battle, then got in between the defendant and Miss Battle and told the defendant not to speak to Miss Battle that way. At that point, the defendant shoved Miss Battle in the face and then struck Justin Battle in the face and head. As a result, the victim sustained swelling to his forehead and a laceration to the right side of his face. Both the defendant and Justin Battle do reside at this incident location together. We did have an opportunity to speak with Mr. Justin Battle and Miss Pamela Battle. They confirmed the events in the warrant. Miss Battle stated that the defendant has a drinking problem and needs help with his drinking. She said that the defendant was under the influence at the time of this incident and that this is not the first time he has been violent towards his family members, but it is the first time he has been violent toward Mr. Justin Battle. Both Mr. Justin Battle and Miss Pamela Battle stated they do not want contact with the defendant. They want him to stay away from the residence, and he will need a one-time law enforcement escort to retrieve his belongings. We are, for that reason, as well as the prior convictions for family violence battery and simple battery family violence, asking for a $3,000 surety bond, no further contact with Justin Battle, stay away from 932 Natham Drive in Atlanta, Georgia. We are asking for family violence intervention, as well as no alcohol, drugs, or weapons. At this time, we would like to sound for Miss Pamela Battle, and Mr. Justin Battle.
Ms. Pamela Battle, Mr. Justin Battle is on the line and wishes to address the court. Now is your opportunity to do so. Does not appear so. Mr. Cook?
Your Honor, it's my understanding that that Justin Battle does not live there, but if indeed that is true, my client would have no problem with a stay away from that location and no further contact until this is resolved. We would be seeking a signature bond at whatever level the court deems appropriate. We would object to the family violence intervention program. That would be it, Your Honor.
It'll be a $2,000 good bond. No further contact with either Pamela or Justin Battle. Stay away from the Nathan Drive address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Battle.
Thank you, Your Honor.
Next, we go to position number 6 and 7, Brian Bradley.
Good afternoon, Mr. Bradley. You've been charged in case 24CR002402F with simple battery, family violence, and criminal trespass, and in case 24CR002403F with willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
37. Open simple battery DV. Disorderly conduct out of DeKalb County. Got an open battery DV out of Fulton. 22CR007723. 2018 burglary. 2017 theft by receiving. 2017 probation, shoplifting conviction. 2017 trespass, and 2016 theft of property.
Thank you. Ms. Falk?
Yes, Your Honor. Beginning with the let's see. Beginning with the family violence offense. This is a simple battery, family violence, and criminal trespass in September of 2023 at 865 Fox Street in Atlanta. The first incident, the one on September 18th of 2023, law enforcement was dispatched to Ava's Place Apartments at 865 Fox Street and met with Miss Africa Mobley, who stated that her ex-boyfriend, the defendant, with whom she previously had lived, fought her and cut up 2 of her couches in the apartment. The 2 had gotten into a dispute over property during which the defendant struck her about the body before proceeding to cut up her 2 living room couches with a sharp object. The officer did document the damage to her property on body-worn camera. On the second incident, the obstruction, this took place on January 30th of 2024. Law enforcement officers made contact with the defendant on foot at One Backyard Way in Atlanta while patrolling the area. The defendant matched the description of an earlier case involving an entering auto. When the officer ran the defendant's information through the system, it showed the valid warrant for the simple battery family violence, and the officer did attempt to arrest the defendant, at which point he fled on foot and disappeared behind the MARTA station. As you have heard, this defendant does have history of family violence battery, including the family violence battery case that was transferred to the DA's office, which is a 2022 incident, and a simple assault family violence disposition unknown, and that was a 2022 case as well. Based upon this, the state is asking for the following bonds. On the first case, which involves the simple battery, family violence, and criminal trespass, we are requesting a $1,500 surety bond. That's going to be $1,000 on the simple battery, family violence, $500 on the criminal trespass. And we are asking for no further contact with Africa Mobley. Stay away from Ava's Place at apartments located at 865 Fox Street in Atlanta, Georgia. And no alcohol, drugs, or weapons, as well as family violence intervention program. On the second case, which is the obstruction, we're asking for a $500 surety bond. We're asking for no additional conditions as to that bond, which would be a total of $2,000 surety bond with those conditions as stated. At this time, we would like to sound from Ms. Africa Mobley.
Ms. Mobley is on the line and wishes to address the court. Now is your opportunity to do so. Mr. Cook.
Your Honor, my client denies the charges as stated in the warrant. He is not working at the moment and so would have difficulty making a surety bond. We have no problem with the no further contact or the stay away. He does not live at that address. We would object to the Family Violence Intervention Program. We would be asking again for a signature bond at whatever level the court deems appropriate.
Ready. Position number 6, the simple battery will be $1,000 good bond. The criminal trespass will be a $500 good bond, makes for a total of a $1,500 good bond. No further contact with Ms. Mobley. Stay away from the Box Street address. No drugs, alcohol, weapons while out on bond. Position 7, the obstruction, a $500 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Bradley.
Next, we could go to position number 8. Mr. Chapman.
Good afternoon, Mr. Chapman. You've been charged in case 24 CR 002409B with driving under the influence of alcohol, reckless driving, driving while your license was suspended or revoked, and possession of an open alcohol container. Is there a history, Mr. Howard?
7 on probation out of Hennepin County in Minnesota, DWI, while operating a motor vehicle. 2018 probation and 2017 DUI conviction. That's it.
Falk.
Yes, Your Honor. This incident happened April 27th at 4220 MLK Junior Drive in Atlanta. Law enforcement observed a vehicle coming at them going the wrong way down the road. The deputy had to swerve in order to avoid a head-on collision with the defendant. At that point, he operated his emergency lights. The vehicle came to a stop. The officer made contact with the defendant, observed an alcoholic bottle in the back seat of the vehicle, and also smelled the odor of alcohol coming from the defendant. At that point, the officer attempted to speak with the defendant, who refused to speak to him. Upon running the defendant's license, it showed that his license was suspended. He also, another officer, an assisting officer, made contact with the defendant as well, smelled the odor of alcoholic beverage coming from the defendant's breath. The defendant was slurring his speech, had eyes that were glassy, and the officer also saw an open Hennessy bottle in the back seat. At that point, the defendant was asked, FST was attempted and refused, and the defendant was placed under arrest. As you've already heard, the defendant has at least 2 DUIs convictions within the last 10 years. One in 2017 in Georgia, one in 2023, which was just last year, which was a concentration of 0.08 within 2 hours. And that was out of Minnesota. And so for that reason, as well as the fact that the defendant almost had a head-on collision with a law enforcement officer, we do have some serious concerns about this defendant continuing to drive, even though 1, his license is suspended, and 2, he has 2 DUIs. So for that reason, the state is asking for a $5,000 surety bond. That's going to be $3,000 surety bond on the DUI, a $1,000 surety bond on the driving while license suspended, on the reckless driving, and a $500 surety bond on each of the driving while license suspended and open container charges. We're asking for no driving whatsoever during this time. His license is suspended, so that should not be difficult for him to comply with, and no alcohol, drugs, or weapons. That's all for the state.
Mr. Cook, is this your case?
Yes, Your Honor. We would ask the court to consider a lower bond amount given his financial circumstances. Beyond that, we would simply defer to the judgment of the court.
Okay, for the DUI, it'll be a $3,000 good. For the reckless, a $1,000 good. For the suspended license, a $500 good. For the possession of an open alcohol container, a $500 good. makes for a total of a $5,000 good, no driving without a valid license, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Chapman.
Next, we will go to position number 9, Mr. Roland Collins.
Good afternoon, Mr. Collins. You've been charged in case 24 CR 002412E with battery. Is there a history, Mr. Howard?
Fourth. Last arrest was 1999.
Okay, Spock?
And my apologies, Your Honor. I was just getting that information on the last case put into the system. What is this case?
Position number 9, Mr. Collins.
Collins. All right. Thank you, Your Honor. This incident happened on, let's see, just drop my Collins. April 27th of 2024 at 515 North Central Avenue in Hapeville. Law enforcement officers responded to that location, which is the Domino's, and spoke with Mr. Cavante Pitts, who stated his coworker had struck him with a baseball bat. The two of them had gotten into a verbal dispute during which the defendant tried to persuade Mr. Pitts to hit him. The defendant then pulled pepper spray out of his pocket, at which point the Mr. Pitts slapped the defendant to defend himself. The defendant then attempted to spray him, but was unsuccessful. At that point, the defendant actually left the restaurant, went to his car, grabbed a baseball bat, returned back inside the restaurant, and then proceeded to swing the baseball bat at Mr. Pitts' head. Mr. Pitts was able to block the strike with his left wrist, and officers were able to observe that Mr. Pitts had redness and swelling to his wrist from this incident. Given the nature of this offense, and especially the fact that Mr. Collins could have discontinued this matter by just walking away and instead went to his car, grabbed a baseball bat, and definitely escalated this, we are asking for a $2,000 surety bond, no further contact with Cavante Pitts, stay away from the Domino's at 515 North Central Avenue in Hapeville. We're also asking for anger management and no alcohol, drugs, or weapons. At this time, we would like to sound for Mr. Cavante Pitts.
If Mr. Pitts is on the line and wishes to address the court, now is your opportunity to do so. Mr. Cook?
Here, my client denies the allegations as stated in the warrant. We do not object to a no further contact or a stay away. We would object to the anger management. We would be asking the court for a signature only bond through whatever level the court deems appropriate.
And Your Honor, I would just like to point out that the victim in this case, Cavante Pitts, is 17 years of age.
Okay. It will be a $3,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with Mr. Pitts, stay away from the Domino's on North Central Avenue, no drugs, alcohol, or weapons while out on bond.
And Your Honor, is that oh, sorry, Your Honor, is that a $3,000 signature bond?
Yes, $3,000 through pretrial level 1, 1-day anger
Thank you, Your
awareness. Okay.
Thank you, Your Honor.
Next, we can go to position number 10, Mr. Kawan Curry.
Good afternoon, Mr. Curry. Let's see, you've been charged in case 24 CR 002413D with discharge of a firearm on or near a public highway or street and reckless conduct. Is there a history, Mr. Howard?
No.
Ms. Falk?
Yes, Your Honor. This incident happened on April 27th of 2024 at 1955 Compton Drive in Atlanta. Law enforcement officers were working an extra job near that location, which is South Bend Park. The officer was on scene with a woman there talking about the rules for bouncy houses for the children who play in that park when they heard 8 gunshots coming from the rear of the park. The officer relocated there and was waved in by an individual who directed him to the basketball court. At the basketball court, the officer observed 2 males entering gray sedans as the officers approached. He parked near them, exited, asked to see if see their hands, and asked if anyone had any weapons in the vehicle. The defendant, who was seated in the right rear of the car, was breathing heavily, attempted to hand the officer a Taurus firearm from the center console. The officer also asked if there were any more weapons in the vehicle, and the passengers, as well as the defendant, affirmed that the officer had all the weapons. The officers then saw in plain view a long gun on the floorboard. At that point, the defendant and the other passengers were detained, and the other weapons were secured at that location. Shell casings were found approximately 15 feet away from where one of the individuals fired one of the guns found, and a witness there informed the officer that the shirtless male, who was identified as the defendant, was the one shooting the long gun that the officer recovered from the floorboard. I do understand that this is a first arrest, but this happened in a park during hours where people are out playing and just trying to live their lives and interacting. I mean, somebody was actually trying to go over the rules and regulations for a bouncy house for their children, and you have people shooting guns in that area. There's nothing more dangerous than that situation. For that reason, the state is taking a very strong stance on this. These bullets could have gone anywhere and harmed anyone. We are asking for a $15,000 surety bond. That's going to be broken up as follows. $14,000 for the reckless conduct, and $1,000 for the discharge of firearms near public highway or street. We would also ask for no alcohol, drugs, or weapons, no firearms whatsoever, and that any firearms that are in the possession of this defendant be surrendered. Finally, we're asking the defendant stay away from South Bend Park, located at 1955 Compton Drive in Atlanta, Georgia. That is all for the state at this time.
Your Honor, we have no objection to the conditions as stated. We would simply note that this is his first arrest. He's 21 years old. We would be asking for a signature bond at whatever level the court deems appropriate.
Okay, for the discharge of a firearm, $1,000 good bond. For the reckless conduct, a $3,000 good bond makes for a total of a $4,000 good bond. No stay away from South Bend Park. Relinquish all firearms, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Curry.
The next, we go to position number 11, Octavian Finley.
Good afternoon, Mr. Finley. You have been charged in case 24 CR 002417J with willful obstruction of a law enforcement officer, 2 counts of battery, family violence, and 1 count of battery. Is there a history, Mr. Howard?
7. Got an open case in Superior Court, terrorist threats, reckless conduct, criminal damage to property, 23 SC 189586. FTA from 2024-2022. Simple battery 2019-2018 trespass. It has a 1 out of McRae, Georgia. I don't know what it's for though.
Walk.
Yes, Your Honor. And if I can ask pretrial, can you give me the case number on that terroristic threats case again? I just wanted to look at something real quick.
23 SC 189586.
Okay. Sure. Okay, I just wanted to look at who the victim was on that case, Your Honor, just to get an idea. All right, so this incident happened on April 25th of 2024 at 2914 Blunt Street in East Point. Officers responded to a fight call at that address. Upon arrival, they spoke with Miss Kaylin Finley and Jericho Rozier, who are the defendant's sister and brother, that live at that location with him, and Jose Marilla, who is the defendant's acquaintance of the defendant's mother. Each of the victims stated that the defendant assaulted them with within the home and in the presence of the other family members. The defendant struck Kaylin Finley and Jose Marilla in the face, leaving them bleeding and with a laceration on the inside of their mouths. The defendant also struck Jericho Rozier in the eye, leaving him with swelling to his eye. After detailing the incident and the information to dispatchers, the defendant then grabbed Miss Finley's iPhone and fled on scene by foot and later then by vehicle. The officers did initiate a pursuit during which the defendant hid from the officers and then fled from them in further disregard of the lawful commands to stop. Just taking a look at, it looks like the defendant has bench warrants, a dormant bench warrant for a 21 CR 000841J case, which is the case for which he was released on a simple battery family violence involving his mother. It also looks like there's a judicial hold on that terroristic threats case as well, which is the 23 SC 189586 case. Just going back and looking at that, it looks like the order for the judicial hold was done on November 2nd, 2023. And it states that the defendant was unavailable for prosecution, which is why the judicial hold was done in that case. Looking at the bond order on that case as well. Okay. It looks like in that case, the terroristic threats, one of the bond conditions was no further violent contact with any member of the family. That was issued on January 31st, 2022. So he is in violation of that condition of his felony bond. That plus the fact that the defendant has these two outstanding cases as well as FTAs from 2022 to 2024 just add up to a defendant who was at a high risk of reoffense as well as a great likelihood to not appear for court, being that there's already a judicial hold on him in misdemeanor court with a bench warrant pending on him. For that reason, the state is asking for a $5,000 surety bond. That's going to be $500 on the obstruction, $1,500 on each of the batteries. No further contact with Kaylin Finley, Jericho Rozier, and Jose Marilla, as well as stay away from 2914 Blunt Street in East Point, and no alcohol, drugs, or weapons. Just checking for a moment to see if we have any information from the family members. Not, but at this time, we would like to sound for those victims.
If Ms. Kaylin Jericho Rozier or Jose Marilla is on the line and wishes to address the court, now is your opportunity to do so. Mr. Cook.
Your Honor, from my information, looking at the paperwork, my client's been in custody initially at East Point since April 25th. That puts us well past the 72-hour requirement of 17-426 OCGA. I understand he has other holds, but for that reason, the sanctions are obviously not all that clear in that statute, but the statute's there for a reason. We would ask for a signature-only bond through the jail due to that violation of the statute.
Ms. Falk.
Your Honor, I will say that we disagree with the interpretation of that portion of the statute. He was, in fact, transferred from East Point Police Department. It looks like the warrant was taken out on this case after his and he was not transferred over to our jail until it looks like his booking date was the 27th at 5:18 a.m. So under any circumstances, he would not have made Saturday court. He would not have actually been seen until today. And so for that reason, we were asking for the bond as we have requested it.
Your Honor, we obviously have a disagreement on the interpretation. It's up to the state to present these people at the appropriate time. So again, we believe the 17-426 statute holds, and he would be deserving, or a signature only bond is required in this kind of situation.
And Your Honor, my response to that is even if we had court on Saturday, he would not have made the cutoff. He was not booked in until after the cutoff on Saturday. And so he wouldn't have been presented to this court until today. In any circumstance, he would have been showing up today for court.
Okay. For the obstruction, it's going to be a $2,000 signature bond. For each of the battery charges, it's going to be a $5,000 signature bond. Makes for a total of a $17,000 signature bond through the jail. No further contact with Ms. Finley, Mr. Rosier, or Mr. Marilla. Stay away from the Blount Street address. No drugs, alcohol, or weapons while out on bond. Good
Your
luck to
Honor,
you, sir.
we would like to ask that he be released only to the hold. He does have an outstanding hold for which he is currently in custody out of Telfair County.
Okay, well, if he has a hold, then he's to be released to the hold. And if he has, did he have anything further with the open Superior Court case?
No, but I will be in contact with it. I'm kind of a little at a loss why he doesn't have the bench warrant on the misdemeanor case that has been applied through the jail. So I will double check with the jail for those two issues, both the felony and the misdemeanor bench warrants.
Okay, thank you. All right, good luck to you, Mr. Finley.
Next, we will go to position number 15, Jonathan Jackson.
Good afternoon, Mr. Jackson. You have been charged in case 24 CR 002399C with theft by deception. Is there a history, Mr. Howard?
Ninth arrest. Open disorderly conduct out of the cab. 2020 escape. Before that was a 2010 armed robbery conviction. I think he got sentenced to 10 years for that and wanted out of Clayton County.
Ms. Falk?
Yes, Your Honor. I'm just pulling up Jonathan Jackson. Just a moment. Okay, so this incident happened back on March 28th of 2024. This occurred at on March 28th, 2024, the defendant pawned a necklace at Easy Pawn, which is also called Jerry's Pawn. On March 27th, an employee at Hartsfield-Jackson Atlanta International Airport had a necklace stolen at the employee security checkpoint by another employee. Utilizing the cameras, the officers observed the defendant as the person who stole the necklace. At that point, a Clayton County magistrate warrant was taken out for this defendant for theft by taking. The officer then checked the defendant's name against pawn records and saw that the defendant had pawned the pendant from the necklace, which was a gold and diamond fleur-de-lis New Orleans symboled necklace at Easy Jerry's Pawn at 21 Decatur Street in Atlanta, Georgia. On March 28th at 12:50 p.m. for $300. The officers were able to recover the pendant from the pawn shop on April 11th of 2024, and it was the same necklace that was with the recovered pendant matched exactly the necklace that was stolen. In this situation, the officer also got the pawn ticket, which showed the item was pawned by the accused. Let's see. I'm just checking for any notes from our victim. Sorry, Your Honor, we have a lot of defendants today, so I'm just going through and making sure I'm not missing anybody. All right. Doesn't look like we are missing anyone, so I'm not seeing any notes in reference to Mr. Jonathan Jackson, but I'm sure the victim advocates will text me in the chat if I am. I will say that it looks like the defendant also has a foreign hold from Clayton County, which I'm assuming is the hold from the incident that happened, the theft by taking there. Given the fact that he is mainly responsible for that theft by taking, and that is the primary felony charge, we are agreeable to a $2,000 signature bond through the jail and that he be released to the hold in Clayton County. We're also asking that he have no further contact with the victim. And let me just get his name really quickly. Let's see. Just see. The victims, oh, well, I mean, the victim in this case, I was actually thinking of our victim in the theft, but the victim actually in our case would be Easy Pawn. So we're asking that he just stay away from Easy Pawn as a condition of that signature bond through the jail.
Thank you.
And that's all I can state.
Any objection to any of that, Ms. Atai?
No objection, Your Honor. No objection to the signature bond through the jail.
Okay, it'll be a $2,000 signature bond through the jail. Stay away from Easy Pawn on Decatur Street. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Jackson.
We have our position number 16, Mr. Justin Johnson.
Good afternoon, Mr. Johnson. You've been charged in case 24 CR 002391E with simple battery. Is there a history, Mr. Howard?
6 on probation, ag assault, simple battery, cruelty to children. 22 SC 184 911. 2020 simple assault DV conviction. 2019 simple battery arrest. 2017 theft by receiving. 2017 simple battery DV dismissed.
Ms. Falk?
And Your Honor, this is Mr. Justin Johnson.
Yes, position 16.
Okay. So this incident happened on April 28th of 2024. In this incident, the defendant, officers were called to 675 Hanley Avenue in Atlanta, Georgia, to a fight in progress. The caller stated the defendant was acting aggressively to her, and her name is Christian Johnson, and her grandmother. Officers arrived at the scene and spoke with Miss Christian Johnson and Nadine Pope. Miss Christian Johnson is the victim. Miss Nadine Pope is the grandmother. They stated that Mr. Johnson came home drunk after being gone all day and got into an argument with Miss Pope, who is the grandmother, about being unable to park his vehicle on the grass. As this argument escalated, Miss Christian Johnson joined and told the defendant to relax and drop the argument because he was drunk. At that point, the defendant snapped and began arguing with Miss Johnson because she took her grandmother's side. The defendant then struck his sister with a closed fist, making contact with her left cheek. At that point, the two of them began fighting, and the defendant pushed Miss Nadine Pope to the floor. Miss Nadine Pope was questioned by the officers at the scene. She stated she doesn't remember much of what happened, but she ended up on the ground. She did claim that she may have slipped because the floor was wet. She wasn't sure, but she did state to police on that day, all that she knows is that she wants the defendant gone. And that is essentially, in a nutshell, the incident as it occurred that day. Mr. Johnson was taken into custody at that time. As was stated, the defendant has a previous arrest for simple battery from the arresting agency was the Georgia World Congress Center. He also has a 2020 simple assault family violence conviction where he was found guilty in 2023 in Fulton County State Court and was given 12 months probation on that offense. Finally, he has a Fulton County Superior Court family violence, simple battery, aggravated assault, and cruelty to children in the 3rd degree. On that case, he was given first offender, and it appears that happened January 24th of 2024. He is currently still under probation under that offense. He was given 5 years probation on that case. Just double checking, I just want to see February 9th, 1996. The victims on that case. Okay. On the criminal trespass, simple assault case, he was found guilty on. That was in March 23rd of 2023. And it appears that the victims were Jewel Lundy in that case. In the other case, the felony case, it looks as though the victims in that case, where he is currently under first offender, were Jewel Lundy as well, and as well as Kay Johnson, who is our victim. She was the victim in a cruelty to child in the 3rd degree. And so I believe she was the person present in the felony case under the cruelty to children 3rd degree that she witnessed the event. And she is on this Senate sheet as well. The defendant was also told to complete family violence intervention program as a result of this, and do community service. I'm not sure if any of that has been done at this point, since he was just convicted of that or placed on first offender on that case in January of 2024. But all of this adds up to an individual who is going to, in our opinion, continue to violate the law, especially when it comes to family violence, as well as continue to use alcohol, which, he is not supposed to be using that while he's out on probation, no alcohol, drugs, or weapons. So he is violating that as well. For that reason, we are asking for a $3,000 surety bond, as well as stay away from Miss Johnson and Miss Nadine Pope, as well as a stay away order from their residence, and no alcohol, drugs, or weapons. That's all for the state. We would like to sound for the victims in this case, which would be, just going back, Miss Johnson, as well as Miss Nadine Pope, Miss Christian Johnson and Miss Nadine Pope. That's all for the state.
Either Miss Johnson or Miss Pope are on the line and wish to address the court. Now is your opportunity to do so. Mr. Ty.
Your Honor, my client is 28 years old. He is the father of a 7-year-old child that he is the primary caretaker for. He firmly denies the allegations in the warrant and states that his sister and brother jumped him. If you can see his face right now on the call. He has severe injuries to his face. He has scratches everywhere. The warrant states that the police asked him how he got the scratches on his face and chest. His eye is swollen. His jaw is swollen. He's bruised. If he can pull down his mask, you can see the extent to which his jaw is swollen, Your Honor. He's been beat up. So he of course denies the allegations as stated in the warrant and states that his sister and his brother attacked him. I would ask for a signature bond, and I understand he has history, Your Honor, but I would ask for a signature bond through pretrial services. Obviously, this was not an attack on his part. And I haven't been able to speak with the complaining witness, Christian Johnson. So I guess in that case, there would be a stay away and no further contact, which is fine.
Your Honor, we did have an opportunity to speak with Miss Christian Johnson. She did confirm the events in the warrant. She stated this is not the first time the defendant has been violent toward her and their grandmother, Miss Pope. She stated that when the defendant drinks, he becomes violent, and that after the incident, she locked him out of the home and he broke the windows of the house. She stated she is okay with no violent contact, but wants him to stay away from the residence, and he will need a one-time law enforcement escort to retrieve his belongings. As I stated, we are somewhat departing from that in that we are asking for no further contact whatsoever for the time being.
So it will be $2,000 good bond, no further contact with Christian Johnson or Nadine Pope. Stay away from the Henley Avenue address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Johnson.
Your Honor, what was that bond amount again? I apologize.
No, you're fine. 2,000 good.
All right, thank you. And Ms. Falk, I sent you a message in the chat.
Yes, sir. I will check right now. Thank you.
Rhonda?
Oh, Devin Williams. Sorry. Devin Williams was supposed to be a PAD referral. I have not heard back, and let me just check my emails, but I haven't heard anything back from PAD as to the status of the two cases I referred. But they are both PAD referrals, so that's why we did not accuse the cases, because it appears that Devin Williams, I did get an email, declined to be connected with PAD. I will go ahead and draw that up now.
Thank you.
Yeah, and he out on
Thank you.
pretrial anyway, so it's gonna be surrendered.
Got it. I will go ahead and work that case up right now so we can get him added onto the calendar.
Who do we have next?
Position
Officer-
30, I'm sorry, Your Honor. Position
No, go ahead.
37, Ms. Wright.
Good afternoon, Ms. Wright. You have been charged in case 24 CR 002396A with driving while your license was suspended or revoked, no insurance, and headlights required. Is there a history?
Third, 2023 suspended license NOLO. Appear to be on probation for that. This either the second or the third. That's all I got though.
Okay. Ms. Falk?
Yes, Your Honor. Let's see. Okay. My apologies. I was actually just about to work up this other case when Your Honor. Okay. So as for Miss Wright, Your Honor, we're showing that this incident happened on April 27th of 2024. During this incident, the warrant is actually pretty brief on this case, Your Honor. It just states that she was driving. The officers observed a silver in color Acura driving on Old National Highway near Jolly Road with a defective headlight. The officers activated emergency lights, conducted a traffic stop. They told her the reason for the stop. She did have a suspended license due to a failure to appear and did not appear to have valid insurance. The state's recommendation is going to be a $750 signature bond through the jail and no driving as long as she does not have a license or insurance. No alcohol, drugs, or weapons. That's all for the state.
$250 per charge.
Yep, $250 per charge, Your Honor.
Any objection to that, Ms. Kim?
No objection, but we would like to put this as a record. We have no warrant. It was warrantless on view arrest, and it has been more than 48 hours. So this is a Riverside issue, Your Honor. And also my client says that the first two charges about driving while license suspended and no insurance, she denies the allegation because she took care of it last year and there is no FTA.
Okay, it'll be a $250 good bond per charge, makes for a total of a $750, I'm sorry, $250 signature bond per charge, which makes it for a total of a $750 signature bond through the jail. No drugs, alcohol, weapons while out on bond.
Thank you.
Good luck to you, Ms. Wright.
Next, we can go to position number 17, Mr. Clement Calabata.
Good afternoon, Mr. Kalambata. You have been charged in case 24 CR 002418F with battery family violence. Is there a history, Mr. Howard?
Second arrest on probation for DUI in state court.
Ms. Falk? Mr. Graham?
Thank you, Your Honor. So this incident took place in February 16, 2024. Law enforcement responded to a domestic dispute at 621 Greenhouse Drive in Roswell. Upon arrival, Diana Nkonde, Nkonde, advised that her husband, Clint Calambata, was having withdrawals and hallucinating. She explained that he kept leaving the residence, knocking on neighbors' doors, became upset. When she made him come inside. He struck her several times with a baseball bat and only stopped when she bit his hand. Once she was able to take control of the bat, Mr. Kalambada jumped from the third floor balcony. Police located him running through the apartment complex. He was yelling, waving a walking cane. He appeared to be in an extreme state of paranoia. He had lacerations to his feet and hands, as well as a large hematoma on his head. Your Honor, we have spoken to his wife, Miss Diana. She tells us that they've been married since 2018. They have no children. They reside at 621 Greenhouse Drive. Now, they have no domestic violence history. She's not afraid of him. She confirmed the events in the warrant, stated nothing like that had ever happened before. She believes he thought that she was someone else and that he was hallucinating, that someone was chasing him when he jumped from the third floor balcony. He has since been in treatment and everything has been okay since then. She'd like to maintain contact and for him to return to the residence. Your Honor, based on the statement of Ms. Nkande, the state is recommending a signature bond through pretrial services that Mr. Kalambada remain compliant with the treatment that he's currently receiving, no further violent contact with his wife, no alcohol, drugs, or weapons. And if we may sound for Ms. Diana Nkande at this time, Your Honor.
Mr. Conte, if you would like to address the court, now is your opportunity to do so. I'll need for you to unmute yourself.
Your Honor, if she's going to testify anything about MH, we would like to request for a breakout room. I didn't think it was going to be addressed, but I think that's important that we address at the breakout room if she is going to testify about that.
Okay, Ms. Nakante, we are live on YouTube. I would not like for anything that you say to address any type of mental health issues, but if you want to tell me things like you're not afraid of him and you want him to come home, I'm happy to hear you on those issues, okay? So if you can raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down, ma'am. What would you like to tell me?
No, I'm not afraid of him. He can come home and he only did what he did because he was confused, hallucinating. That's the first time he did it.
Okay, and you all have been together since February 16th when this allegedly happened?
Yes,
Okay, and everything's been okay since then?
yes, Your Honor.
Okay, all right. Thank you for being here this afternoon, Ms. Nakande.
Thank you.
Anything further, Ms. Kim?
No, nothing further from defense, Your Honor. We are okay with signature on bond and no further violent contact.
Okay, it will be a $2,000 signature bond through the jail. No further violent contact with Ms. Nakande, and no drugs, alcohol, or weapons while out on bond. He's also to remain compliant with any treatment that he is currently receiving. Good luck to you, Mr. Kalambata.
What was that contact?
No further violent contact. Who we have next?
You can go to position 24, Dion Mosley.
Good afternoon, Mr. Mosley. You've been charged in case 24 CR 002406F with theft by taking and possession and use of drug-related objects. Is there a history, Mr. Howard?
33. 2015 burglary conviction. 2014 shoplifting conviction. 2012 burglary conviction. 2011 parole violation. That's it.
Graham?
Thank you, Your Honor. This incident took place April 27, 2024. Alan Mosley was observed stealing the Georgia Tech Police Department's bait bike. It was located at the Scheller College of Business at a bike rack on the Georgia Tech campus. He was detained a short distance later. A search incident to arrest yielded a metal marijuana pipe containing burnt residue. Your Honor, based on the history, the state is requesting a $1,500 signature bond. That's $1,000 on the theft by taking and $500 on the drug-related objects. Stay away from the Georgia Tech campus. No alcohol, drugs, or weapons while out on bond.
Sit time.
Your Honor, I don't have any objection to the $1,500 signature bond and the stay away from the incident location.
Okay, for the theft, $1,000 signature bond through the jail. For the possession, $500 signature bond through the jail, makes for a total of a $1,500 signature bond through the jail. Stay away from the Georgia Tech campus, no drugs, alcohol, weapons while out on bond.
And Your Honor, just for the record, the recommendation was a $1,500 surety bond, but I understand your ruling.
Okay, thank you, Mr. Graham.
Next, we can go to position number 29, Mr. Ramirez.
Good afternoon, Mr. Ramirez Savion. You have been charged in case 24 CR 002394G with simple assault. Is there a history, Mr. Howard?
Third arrest. 2023 open escape in state court. It's 23 CR 008 204G. 2017 aggravated burglary.
Falk?
Yes, Your Honor. This incident happened on April 24th of 2024. Mr. Ramirez approached a male with a knife. Essentially, the incident that happened was the caller, Mr. Shane Maneri, stated he was an Uber driver coming to pick up his customer at 12:15. He then stated he saw the defendant standing at the location. He assumed it was his customer. He asked the defendant if he was the person he was picking up. The defendant then, Mr. Maneri stated he then saw the defendant pull out a knife and walk toward the vehicle. At that point, he drove back onto the roadway to get away from the defendant. And he stated that the defendant never raised the knife, was just walking toward him. Miss Amber, who was a witness, also stated she observed the incident. She said that she was actually the fare he was meant to pick up, Mr. Maneri, and that when she arrived at the location, she saw the defendant with a knife in his hand and Mr. Maneri driving off. Going to his history, out of curiosity, pretrial, the escape, was that a pretrial services bond or a bond through the jail?
I have no idea. I'll look it up real quick.
Yeah, if you could. I'd appreciate it. Thank you.
Well, excuse me just a second.
Yes.
Miss Calhoun, would someone please turn off Miss Calhoun's camera, please, and do not turn it back on until she is no longer doing laundry, eating, or she's disrupted this court twice now.
Okay, Judge.
Thank you. I'm sorry, Ms. Falk, go ahead.
Of course, Your Honor. And I am just asking to see, because I was unaware of the escape charge. So I was just trying to find out the status of that. And I can look it up really quickly as well. We would like to also sound for Mr. Shane Maneri. It looks like on that escape charge, Your Honor, let's see, the defendant was given a $2,000 surety. Oh, wait, nope. A signature bond was actually granted. It was $3,000 SOB through the jail. For that reason, we were asking that the pretrial services come off of that bond, but we are agreeing to a $3,000 signature bond on this offense, while we are also asking for these pretrial services to come off of his $3,000 signature bond on the escape charge.
But the 3,000 was 3,000 with SOB jail, so there's nothing to come off.
Oh, it's SOB jail? I thought
Hold
it was
on for a
SOB
minute.
through pretrial.
Yeah, that's jail.
Okay. All right. So we would ask for a $3,000 signature bond through the jail due to the time constraints, Your Honor.
Okay. Who's representing Mr. Ramirez?
Your Honor, that is my client. We have no objection to the $3,000 signature bond through the jail. Mr. Ramirez was, of course, arrested on April 24th, and he's been in custody since then. So I think this clearly violates the 72-hour rule under 17-426. but we have no objection to the signature bond.
Okay.
And Your Honor, oh, so sorry for interrupting, Your Honor. We would just like to sound for Mr. Shane Maneri, if he is here.
Mr. Maneri on the line? Okay, $3,000 signature bond through the jail, no further contact with Mr. Maneri, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Ramirez. Thank you, Mr.
Judge.
Gray.
Next, we will go to position number 30. Mr. George Shabir.
Yes, good afternoon, Mr. Shabir. Let's see. Oh, Mr. Shreve, excuse me. Good afternoon, Mr. Shreve. You've been charged in case 24 CR 002408G with battery family violence. Is there a history, Mr. Howard?
Yeah, hold on real quick. Check your check. 31 total. 2021 theft by receiving, possession of marijuana. Before that was that 09 conviction I just gave you. 06 ag assault, false imprisonment, terrorist threats, possession of a knife or a firearm during a conviction. I gotta run down the hallway for a minute. I'll be back.
Okay, Mr. Graham?
Yes, Your Honor. This incident took place April 27, 2024. Law enforcement responded to a domestic dispute at 2612 Steele Avenue Southwest in Atlanta. Upon arrival, Lit Shannon Calhoun advised that her boyfriend, Extavius Shreve, punched her in the face several times, resulting in a busted lip. Mr. Shreve was inside the residence sleeping at the time. He was taken into custody. Officers noted lacerations on his hands and knuckles. He told the officers that he had been drinking prior to the incident. We have been in touch with Ms. Calhoun, Your Honor. She states that the two have been together for about 3 months. They have no kids. They do reside together at 2612 Steele Avenue. She told us that there was an incident that happened 2 days prior to this one where Mr. Shreve was verbally aggressive with her. She stated she called the police before he hit her, and he apologized at that time. She confirmed the events in the warrant, stated she's not in fear of him, would like a no violent contact, anger awareness, and a drug and alcohol evaluation. Your Honor, based on the history and I think the information that you've received from pretrial, the state is requesting a $1,500 surety bond, a one-day anger awareness course, an ADET. At this time, we're going to ask for no further contact with Ms. Calhoun, a stay away from 2612 Steele Avenue Southwest, no alcohol, drugs, or weapons. And of course, I do believe Ms. Calhoun is logged in if we may song for her at this time.
Ms. Calhoun, if you'd like to address the court, I'll need for you to activate your camera for me, and I'll have to swear you in.
Okay, so do you hear me?
Yes, activate your camera for me.
Where's that? I have no idea. Is it hit live or something? I have to start video. It says you cannot start your video because
Yes, we
start my
disabled
video.
you.
Okay, gotcha.
Okay. All right, raise your right hand for me.
All right. Okay.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. What would you like to tell the court?
Nothing.
Okay. Do you want him back in the household?
If he's allowed to, and if he understands no violence, I have no problem with that. I'm not trying to hold him in jail or anything. I just don't want him hitting me. He has no reason to. And I didn't know that he had a drug alcohol problem prior to me moving here, because if so, I would have never lived with him because I do not tolerate that. I don't know his, his alcohol limit or anything like that. He didn't I had no signs of that. I was not aware of that. And it finally crept upon us. So I'm just asking him, could he deal with that and not hit me, not assault me? Because I'm very kind to him. And I think he doesn't appreciate that. And all I'm asking, if we can't get along, will he give me time to leave?
All right, thank you, Ms. Calhoun. Mr. Bray? You're on mute, Mr. Bray.
I'm sorry, Judge. Mr. Shree is 45 years old. He was born and raised in Metro Atlanta. As the court has probably gathered from the testimony of Ms. Calhoun, the incident location is in fact his apartment where he pays rent. He was working in at a catering agency recently, though he quit due to a lack of benefits, but he's now working doing home improvement with ENT. And he also has a 27-year-old daughter who he helps with childcare of her 2-year-old, so his granddaughter. So he's someone with a lot of family ties in the area. He's got an apartment. Your Honor, we are asking for a signature bond. Again, he's got an apartment that he pays for. We're not far off from the position of the state. Fine if that were through pretrial services, Your Honor. As far as no further violent contact no further violent contact, we'll leave that in the discretion of the judge. Ms. Shree, is fine either way, Your Honor. But it is his apartment. His name is on the lease. So we would ask that he be able to return to his apartment at this time. So that is what we're asking for, Judge. We'd be fine with the anger awareness course.
Okay, it's going to be Mr. Graham. Do you have
Yes,
something
sir.
else?
Oh yeah, just wanted to kind of reiterate, based on the statements of the victim, she doesn't seem to be very certain about that contact. The state is still going to recommend no further contact, and I do want to point out that Mr. Shreve was released voluntary manslaughter in 2019. So the state's recommendation for a surety bond and no further contact and to stay away from the residence until Ms. Calhoun has been able to leave still stands.
Okay, it's going to be a $1,500 good bond, no further contact with Shannon Calhoun. While Ms. Calhoun is in the residence, he cannot be there, so I'm not making her leave the residence. But if she leaves voluntarily, at some point he can go back there. He can go back there on one occasion with law enforcement to retrieve any belongings that he might have there while Ms. Calhoun is living there. And once she's no longer living there, if she chooses, then he can go back there. No drugs, alcohol, or weapons while out on bond. Good luck to all of y'all.
Your Honor, may I have position 27 go next? Miss Mallory Pickle.
I was trying to get the private attorney out the way.
Okay, I'll come back to you, Officer Milton.
No problem, Your Honor.
Okay, who do I have courtroom to?
Mr. Williams, Devin, the add-on.
And good afternoon, Judge.
Yes, good afternoon. Again, Mr. Render. Let me give me a moment to pull up this add-on calendar. Let's see. Mr. Williams, good afternoon. You have been charged in case 24 CR 002461F with criminal trespass. Is there a history, Mr. Howard?
Second arrest, open terrorist threat in Superior Court.
Mr. Graham?
Yes, thank you, Your Honor. This incident took place April 28th, 2024. Mr. Devin Williams was found inside of Sydney's Pampered Peach Daycare Center. He was found by the owner, Cynthia Busby. He had entered the daycare center from one of the windows. It was over the weekend when Ms. Busby was able to make contact with him. He told her that he was hungry, so he broke in to make himself something to eat. The state is recommending, Your Honor, a signature bond through pretrial services, a stay away from the incident location. That's Sydney's Pampered Peach Daycare Center. It's located at 4535 Derrick Road in South Fulton. No further contact with Cynthia Busby and no alcohol, drugs, or weapons while out on bond.
Surrender.
Yes, Your Honor, this is a case of mental health, man. Your Honor, this is an individual who's been in the hospital about 3 times in the past year. Last year, he was diagnosed with psychosis, depression, and anxiety. This is a situation whereby when he's not on his medication and he unfortunately is not able to reason in his head, he does certain things in line with this, Your Honor, which does not make any sense. He does have family on the line. They are willing and able to, based on his second arrest on a mental health course, Your Honor, they are willing and able to make sure he's on his mental health treatment. They're willing to make sure he comes back and forth to court. We are in agreement with the signature bond and pretrial status. We would not disagree with that. Based on the family, they do want him to follow his mental health treatment. And so from my understanding, if that could be part of the bond, that's something that they would like to have happen, Your Honor. And that is correct. He has no other history. I am the attorney on the open case, and we are waiting for that as well. So, Your Honor, at this time, we also asked for the PAD program. From my understanding, he was asked that, and unfortunately, because he's not in his right mind, denied that program. But from my understanding, the family would prefer that the PAD program is implemented in this instance. If that is something that you can put a part of the record as well, Judge, we would decline.
Okay, it's my understanding that today he declined the PAD program. But I'm going to go ahead and give him. Is this his mother, Miss Williams? On the line now, Miss Williams.
Yes,
are you gonna pick him up once he's released?
Yeah, either I will or his dad will.
Okay, I just want to make sure that he has that I'm just not letting him out onto the streets. Okay. Anything further, Mr. Render?
Nothing further, Judge.
All right. As such, it'll be $1,000 signature bond through pretrial level 1. Stay away from Sydney's Pampered Peach on Derrick Road. No further contact with this Cynthia Busby. Adhere to any MH treatment plan that he is currently on. And no drugs, alcohol, or weapons while out on bond. Okay. Good luck to you, Mr. Wood.
Thank you,
He's
Judge.
already out on pretrial.
Yes.
Just so y'all know, I'm just letting the court know.
Okay. So I still want him to remain on pretrial. If it's per judge, then that's fine.
What you mean, discharge?
Discharge.
Okay.
He's out. You're telling me, Mr. Howe, that he's out on pretrial for the other
For the
charge.
terroristic threats, yes.
Right,
So that's
right.
surrendered. So now he got discharged.
And Your Honor,
Okay.
based on the surrendering of that bond, we're going to move. Of course, we're going to motion the court for a hearing on the surrendered bond. And I understand that you can't take that here at this hearing, Judge. I understand that.
Okay. All right. Anything further?
Nothing further, Judge.
All right. You all have a good rest of your afternoon.
You as well.
Who do we have next?
ACDC, I'm assuming. Or we can just go to position
It's
number.
wait, Officer Milton's coming.
37, Your Honor, Miss, well, hold on. 27, Miss Mallory Pickle. What happened?
Okay. Good afternoon, Ms. Pickle. You've been charged in case 24 CR 002407Y with battery family violence. Is there a history, Mr. Howard?
Third arrest. 2022 theft by taking dismissed. 2022 battery DV.
And what's the status of the 2022 battery DV, Mr. Howard?
I'm not sure. I didn't put a disposition by it, so it probably wasn't on the GCIC.
Okay. Mr. Graham?
Yes, Your Honor, I have that time expired on that case, but it was the same victim as in this case. And this incident took place on April 27, 2024. Law enforcement responded to a domestic dispute, 549 Atwood Street, Southwest in Atlanta. Kelly Bakers, the victim in this case and the 2022 case, advised that she was physically assaulted by her girlfriend, Mallory Pickle. Ms. Pickle hit her in the head several times with an unknown object. She was not on the scene when law enforcement arrived. Ms. Baker called back when Ms. Pickle had returned to the residence and she continued to be abusive. Ms. Baker was observed with a small cut on her forehead, red marks on her neck and face. Our office has been unable to get in touch with Ms. Baker, Your Honor. But based on the history and the fact that this is the second incident with the same victim, the state is requesting a $1,500 surety bond, a one-day anger awareness, a no further contact with Kelly Baker, stay away from 549 Atwood Street Southwest, no alcohol, drugs, or weapons. And of course, we'd like to sound for Ms. Kelly Baker at this time, Your Honor.
If Kelly Baker's on the line and wishes to address the court, now is your opportunity to do so. Mr. Bray?
Yes, Judge. Ms. Pickle is 37 years old. She was born and raised in Georgia. Her father lives in Colquitt, Georgia, and is coming today to help her out. She plans to move out of the incident location, so we have no issues with the stay away or no further violent contact. But my client, Ms. Pickle, has lived in Atlanta since 2016, so she does have substantial ties to this area. She received a nursing degree from Albany State. She actually just signed a nursing contract with Emory. She's in the process of orientation there, so she is about to work and she is meaningfully employed, Your Honor. Again, she is fine with no further contact, with a stay away, other than the opportunity to go get. She has a dog at the incident location, and then, of course, her belongings. But she's got family on the way to help her out, so she can move out and get on with her life. As far as that prior arrest in 2022, based on Odyssey, that's been dismissed. She was not represented by our office in that situation for obvious reasons. But again, it's been dismissed, and so I would ask the court not to consider that in setting a bond for Ms. Pickle. So, Judge, we would ask at this point for a signature bond through pretrial services. Ask for the one, anger awareness course, no further contact, the stay away, and then, of course, allow her to go back to the incident location one time to get her personal belongings.
Okay, it'll be a $3,000 signature bond through pretrial level 1, one-day anger awareness, no further contact with Kelly Baker, stay away from the Atwood Street address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Pickle.
Next, we will go to position number 31. Mr. Trevon Smith.
Okay. Good afternoon, Mr. Smith. You've been charged in case 24 CR 002410D with DUI less safe, expired tag, and headlights required. Is there a history, Mr. Howard?
Judge, give me that name.
Trevon Smith, position 31.
2022 suspended license NOLO.
Graham?
Thank you, Your Honor. This incident took place April 27, 2024. Trevon Smith was observed driving northbound on Peachtree Street with one headlight out. After initiating a traffic stop, the officer also observed an odor of an alcoholic beverage coming from the vehicle. Mr. Smith's eyes were glossed over, sleepy and bloodshot. He told the officer that he had 2 Coronas earlier at a friend's house. A field sobriety test displayed clues that Mr. Smith was under the influence of alcohol. And additionally, the vehicle's registration was expired. The state is requesting a signature bond through pretrial services, ADET, no driving without a valid license, registration, or proper vehicle equipment, no alcohol, drugs, or weapons while out on bond.
Greg?
Yes, Your Honor. I would just ask for a signature bond through the jail, Your Honor. Of course, he will drive if he's legally able to drive. He was born and raised in Perry, Your Honor. He actually owns a residence in Marietta. He's owned that residence for 3 months. He has 2 children. He pays $1,500 a month in child support for one of those children. His 4-month-old, however, lives in the area with him. He is actually he has a law degree from UGA. He works as an NFL agent with Athletes First. Here, as far as the facts, there's no allegations that there are any driving infractions here, Your Honor, though, the state alleges signs of impairment. And given his lack of history, his employment, and his obligations to his children, I would ask for a signature bond through the jail, and just, of course, no driving unless legally able to.
Okay, for the DUI, it'll be a $1,500 signature bond through the jail. For the expired tag, a $250 signature bond through the jail. Headlights required, a $250 signature bond through the jail. Makes for a total of a $2,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond, and no driving without a valid license. Good luck to you, Mr. Smith.
Next, we go to position number 32, Mr. Stout, Rodney.
Good afternoon, Mr. Stout. You've been charged in case 24 CR 002411A with criminal trespass. Is there a history, Mr. Howard?
66. It says he's on probation for trespass. The disposition says 72 months. 2021 trespass, stalking, reckless conduct, simple battery, simple assault, PI conviction. 2020 burglary, PI arrest. 2018 trespass, no low. Another 2018 trespass, no low. 2018 obstruction, trespass conviction. The trespass is extensive in his history.
Okay. Mr. Graham?
Thank you, Your Honor. This incident took place April 28, 2024. Rodney Stout entered the property of Yolanda Brown at 188 Campbell Street Southeast. He had been told on several occasions to stay away from that property. Our office has spoken with Ms. Brown. She stated, this goes all the way back to 2015 when she moved into her home. In 2016, her dog ran outside and Mr. Stout brought the dog back. She thanked him. She didn't know him at the time or his name. He then came back to the house approximately 10 times. And when she told him that he could not come back to the property, she never called the police because she never really felt threatened. But on the day of this incident, she did. She stated that she was home alone and she saw the defendant on her Ring camera looking high, made her uneasy. While she was waiting for the police to arrive, he climbed the fence and was in her backyard, and she watched from the surveillance camera. He was also sitting on her AC unit, allegedly shooting up drugs. He pressed his face against the bedroom window at one point, looking in. At that point, she pressed her silent alarm, went to her front porch. He went to her front porch to shoot up more drugs. She stated that his actions have escalated to him now going into her yard, peeking into the window. She does not feel safe. She wants no contact, stay away, a drug evaluation, and a possible MHET. Your Honor, based on the history and the allegations, the information from the victim, the state is requesting a $2,000 surety bond, MHET, at the very least, a social worker visit before he's released. No further contact with Yolanda Brown. Stay away from her residence. No alcohol, drugs, or weapons. And if we may sound for Miss Yolanda Brown at this time, Your Honor.
Ms. Brown is on the line and wishes to address the court. I'll need for you to unmute yourself and I'll have to swear you in.
I think that I'm unmuted at this point.
Yes, I can hear you, and there you go. Can you raise your right hand for me?
Yes.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yeah, you can place your hand down. What would you like to tell the court?
I would just like to add to what the attorney mentioned. It has been going on for a long time. And this last incident is definitely an escalation. I have a 6-foot security fence around my home. And to think that he jumped the fence and to get into my backyard and was back there for 20 minutes, I could see him shooting up And then coming to my bedroom window is terrifying. This has been going on a long time, and this is definitely an escalation. And then to go to my front porch and lay on the porch and shoot up more while I'm in here alone is, I just, this is very serious. I don't know what the next escalation will be, but I have knowledge of some of the other incidences with other women in the neighborhood, and I don't want this to happen to me again. I do not. So thank you for allowing me to join.
Thank you for coming this afternoon, Ms. Brown. We appreciate it. Mr. Bray?
Yes, Your Honor. Mr. Stout, he's 52 years old. He's lived in the Atlanta area since 1974. He does have a high school diploma. He tells me he worked for the last year with a Mr. Brooks doing a mobile car wash and lawn service. Your Honor, he does struggle with homelessness. I will refer him to our social workers to put him in touch with services. So then hopefully he can handle that issue. He needs an ID, driver's license, all of those sorts of things that are real barriers to stability. So, Your Honor, I would ask for a signature bond. Anything short of that is just going to guarantee that he remains in jail. And that's what we're requesting the court to impose in this case.
Okay, it's going to be a $2,000 good bond. No further contact with Yolanda Brown. Stay away from the Campbellton Street address. No drugs, alcohol, weapons while out on bond. Mr. Bray, I would ask that he have a social worker visit so that if I'm on that, if he doesn't get out and I'm on that SAP calendar in 2 weeks, I'd like for them to report to me as in regards to either mental health or drug and alcohol issues. If he's not out by that time, and the social worker reports to me, we'll consider a modification of the bond at that time.
Yes,
All right.
Judge. Thank you.
Good luck to you, Mr. Stroud.
Your Honor, he
Yes.
has 2 charges on his booking sheet. The second charge is possession and use of drug-related objects.
Mr.
Oh,
Graham?
yeah, my apologies, Your Honor. So the second charge was an NOD.
Okay.
I'll send that
Okay.
paperwork over. My apologies.
Thank you.
Next, we can go to position number 33, Mr. Antonio Taylor.
Good afternoon, Mr. Taylor. You've been charged in case 24 CR 002415Y with battery family violence. Is there a history, Mr. Howard?
7 total. 2020 battery, 2011 probation, FTA, 2010 simple battery trespass conviction.
Scram.
Thank you, Your Honor. This incident took place April 26, 2024. Law enforcement responded to a domestic dispute at 962 Sells Avenue in Atlanta. Upon arrival, Frances Lovett advised that an argument with her boyfriend Antonio Taylor became physical when he pushed her off of the bed onto the floor, placed his hands around her neck. She fought back by kicking him to get him off of her. The officer did observe scratches on Miss Lovett's neck and chest. Our office has been in contact with her. She states that the two have been off and on for about 3 years. They have no children. They do reside at the 965 Sells Avenue, apartment 5205. She stated they do not have a domestic violence history. This is the first time. She confirmed the events in the warrant. I'll say that Mr. Taylor attempted to choke her, but he didn't. She defended herself. He called her from jail apologizing. She stated that she would be willing to drop the charges if he agrees to leave and go back to his hometown. States that she does not want to pursue charges, but does want a no contact, stay away, and a one-time police escort. Your Honor, based on the history, there's another 2020 battery arrest in Albany, simple battery 2016, and 2010. State is requesting $1,500 surety bonds, a one-day anger awareness. We're going to ask for no further contact with Francis Lovett, stay away from the incident location. Of course, a one-time police escort, and no alcohol, drugs, or weapons. And if we may sound for Miss Francis Lovett at this time, Your Honor.
Ms. Lovett, I see you on the line. If you'd like to address the court, I'll need for you to unmute yourself and I'll have to swear you in.
Hello?
Yes. Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
Well, he said everything. That's all I wanted to do was just drop the case, drop the charges against him. As long as he just stay away from me. That's it.
Thank you for being here this afternoon, Ms. Lovett. Mr. Bray? Case, Mr. Bray?
It is, Your Honor. I apologize. I was trying to unmute myself. Your Honor, Mr. Taylor's 30 years old. He has been working here at APL as a materials handler until he received a foot injury. However, he's in talks to go back and continuing his meaningful employment. Judge, he is fine with a stay away and no further contact with the alleged victim in this case. So I do think there is a 72-hour issue in this case. The citation reports that he was arrested on April 26th of 2024. So I think he's been in custody over 72 hours without appearing in front of a judge, Your Honor. So I would ask for a signature bond through the jail for that reason.
And Your Honor, I would like to say the jail screen arrest date is 4/26/2024 at 4:35 p.m. And so we are 4 minutes shy. So that's all.
Okay. It will be a $2,000 signature bond through pretrial level 1. No further contact with Francis Lovett. Stay away from the incident location. If necessary, he can go back to that location on one occasion with law enforcement to retrieve any belongings that he has there. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Taylor.
Position 26, Ms. Pope.
Okay. Good afternoon, Ms. Pope. You've been charged in case 24 CR 002397G with battery and giving false information to law enforcement. Is there a history, Mr. Howard?
2021 probation, 2020 ID theft fraud, 2019 FTA probation, 2018 probation. On probation in Fayette County for forgery in the first. 2018 obstruction, simple assault, battery DV, cruelty in the third conviction. 2018 ag assault, criminal damage to property, first offender.
Ms. Falk?
Yes, Your Honor. Ms. Pope has holds out of both Cobb County Sheriff's Office and Fayette County Sheriff's Office. So we are agreeable to a $1,000 signature bond through the jail, $500 per charge, and her to be released to either of those holds. I guess whichever tagged her with the hold first would win. The incident that happened was she gave a false date of birth to the law enforcement officer and then bit him.
Okay. Any objection to any of that, Mr. Bray?
No, Your Honor. I would just like to note, I think this is another 72-hour issue. She's been in custody over 72 hours. She was booked on 4/26. So we would ask for the signature bond through the jail.
Okay. For each charge, it'll be a $500 signature bond through the jail, makes for a total of a $1,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Pope.
Next, we could go to position number 36, Mr. Anthony Wilson.
Okay. Good afternoon, Mr. Wilson. You've been charged in case 24 CR 002395A with criminal trespass. Is there a history, Mr. Howard? Mr. Howard?
56 total. Shoplifting, entering auto. That's open. 19 SC 168-533. Got an open case in Superior Court. Theft by receiving suspended license 24 PI 001554. A couple of arrests this year for probation violations. 2018 driving without a valid license conviction. 2018 theft by receiving. Driving without a valid license conviction. And 2017 driving without a valid license NOLO.
Okay, Ms. Falk?
Yes, Your Honor. The incident that happened in this particular case is the defendant entered at 3184 Cherry Street in East Point, which is the property of Carmen Chambers. That location is an abandoned location according to the warrant. And let me just double check to make sure I'm correct about this statement. Yes, it is a boarded up property where no entry into the property was made. And with Ms. Chambers did not give permission for him to be on the property. The state would recommend a $500 signature bond through the jail and stay away from 3184. Let me just make sure I have the address right. 3184 Cherry Street, which is the property of Miss Carmen Chambers. We would not ask for no further contact. It doesn't believe the two of them had contact other than the fact he had been on the vacant property. I would like to sound for Miss Carmen Chambers at this time if she is here.
Ms. Chambers is with us and wishes to address the court. Now is your opportunity. Any objection to any of the state's request, Ms. Kim?
No objection, Your Honor.
Okay, $500 signature bond through the jail. No contact with Ms. Chambers. Stay away from the Cherry Street address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Wilson.
Thank you.
Station 12, Ms. Gonzalez.
Good afternoon, Ms. Gonzalez. You have been charged in case 24 CR 002390E with battery family violence. Is there a history, Mr. Howard?
Third arrest, 2022 battery DV out of Cobb, dismissed. 2021 simple battery conviction.
Ms. Falk?
Yes, Your Honor. I did have the opportunity to speak with Cobb. Neither of the Cobb County cases did involve the victim in our case. However, both cases did involve family violence, both the dismissed case and the case that was pled down from a family violence battery. This incident happened April 26, 2024 at 1426 Jefferson Drive. Justin Purcell had blood on his face at the corner of his nose, as well as multiple scratches on his face, head, neck, and arm, and what appeared to be a bruise or a bite mark on his arm. Mr. Purcell told the officers that the defendant, his girlfriend with whom he shares a 5-day-old child, inflicted these injuries on him. The defendant had no visible markings, nor did she make any mention of any kind of injuries. We did have the chance to speak with Mr. Purcell. He stated that they are in a relationship, currently living together since the birth of their child. They were having a conversation about the children when the defendant became upset and began hitting him. He stated this has never happened before, and he is not in fear of the defendant and wants to continue with contact. The troubling part for the state here is that she only has 3 arrests, Your Honor, and all of them are family violence. One of them was pled down to a simple battery family violence. The other one was dismissed. And now we have this third case. I believe the date of progression was 2021, 2022, and 2024. We do understand she has a 5-day-old child, which is the only reason we're agreeing to pretrial services. We would ask for a $5,000 pretrial services bond, level 3. We would also ask for a family violence intervention program, as well as no further violent contact with Justin Purcell. Again, The only reason we're asking for no further violent contact as opposed to no further contact is the fact that they do hear a relatively young child, as in less than a week old. And for that reason, that's the state's recommendation. We would like to sound for Mr. Justin Purcell at this time.
Mr. Purcell is on the line and wishes to address the court. Now is your opportunity to do so. I see Justin P. there. Mr. Purcell, if you would need for you to unmute yourself and raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
Okay. What would you like to tell the court?
I would just like to just say thank you for your time, and I do agree with everything that's been said. This has been the first time this has happened. I do apologize, and that's all.
Okay, you're not afraid of her and you want her back in the household?
I'm not afraid whatsoever, and yeah, she can come back.
Okay. Thank you for being here this afternoon, Mr. Purcell. Mr. Cook?
We'd have no objection, except to the anger management. Anything else is acceptable. No.
$2,000 signature bond through pretrial, level 1-day anger awareness, no further violent contact with Justin Purcell, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
Next, we could do position number 2. He's waived his appearance.
And that's Eric Anderson, who was charged in case 24 CR 002404G with criminal trespass and damage to property. Is there a history, Mr. Howard?
43. Got an open drug-related objects case. 2020 probation, 2017 FTA, 2016 probation, parole violation, 2010 burglary conviction, and the 2009 burglary, possession of tools, obstruction conviction.
Ms. Falk?
Yes, Your Honor. This happened April 26, 2024 at 1050 Marietta Street. The defendant was at Sterling Bay construction site property pulling a rope at the site. The officers searched the area, located the defendant. The lock was broken and the rope that the defendant was trying to remove is worth approximately $4,000. The incident was recorded on video. This defendant currently is in custody on 20 SC 176481, which is 2 counts of felony theft by shoplifting, for which he's currently being held for no bond. For that reason, the state is agreeable to a $500 signature bond through the jail, as well as stay away from, my apologies, the 1050 Marietta Street Northwest address, Sterling Bay construction site.
Any objection to any of that, Mr. Cook?
No objection, Your Honor.
$500 signature bond through the jail. Stay away from the Marietta Street address. No drugs, alcohol, weapons while out on bond.
What was that amount?
Okay. $500 signature bond through the jail.
Thank you.
You're welcome. That takes care of everyone this afternoon? Yes, I think.
Yes,
okay. I think, yes, Ms. Falk.
Your Honor should have the, we did sign the order for the PAD program for one of the individuals who was on the calendar, and Your Honor should be receiving that shortly.
Okay. So
that is Miss Courtney Jackson.
Okay. So Miss Bridgewater, can you get me that in the paperwork?
Yes, I've received something. I have so much paperwork here. I may already have it, but I'll make sure the judge gets it. I just had to say that, okay?
You want to show us? You want to show us the paperwork again, Miss Bridgewater?
Oh.
Okay.
Okay, so if we're ready, let's go. Once again, the reset date for the SAP calendar is going to be May the 14th. Position number 1 is reset further notice with a $2,000 SOB through pretrial. Position 2 is reset further notice with a $500 SOB through the jail. 3 is reset further notice with a $3,000 SOB through pretrial. 4, reset further notice with a $3,000 SOB through pretrial. Position number 5 is going to the SAP calendar with a $2,000 good bond. Position 6 is going to the SAP calendar with a total $1,500 good bond. Position 7, SAP calendar with a $500 good bond. 8, SAP calendar with a total $5,000 good bond. 9, reset further notice with a $3,000 SOB through pretrial. 10, SAP calendar with a total Position 10 is going to the SAP calendar with a total $4,000 good bond. 11, reset further notice with a total $17,000 SOB through the jail. 12 is reset further notice with a $2,000 SOB through pretrial. 13, reset further notice with a total $2,000 SOB through the jail. 14 is reset further notice with a $5,000 SOB through pretrial per judge. 15, reset further notice with a $2,000 SOB through the jail. 16 is going to the SAP calendar with a $2,000 good bond. 17 is reset further notice with a $2,000 SOB through the jail. 18 is going to the SAP calendar with a $500 good bond. 19 is going to the SAP calendar with a $500 good bond. 20, SAP calendar with a $500 good bond. 21, SAP calendar with a total $1,000 good bond. 22 is reset further notice with a $2,000 SOB through pretrial. 23, reset further notice with a $2,000 SOB through pretrial. 24, reset further notice with a total $1,500 SOB through the jail. 25, reset further notice with a $3,000 SOB through the jail. 26, and I have a question on that first charge. Is it just simple battery or is it simple battery against a police officer? I was reading the warrant and I wasn't sure.
Right. We amended the charge to battery because there is no battery against a police officer. It's just battery. So we amended the charge to a battery offense, being that the officer had a bite mark.
Okay. So with that being said, it is reset further notice with a total $1,000 SOB through the jail. 27 is reset further notice with a $3,000 SOB through pretrial.
What's that level?
That level is 1. Okay, 28 is going to the SAP calendar with a total $3,500 good bond. 29, reset further notice with a $3,000 SOB through the jail. 31, SAP calendar with a $1,500 good bond. 31
You mean
is
30,
I'm
1500
sorry,
good.
30. I apologize. I had such a big calendar. Please forgive me. 30 is going to the SAP calendar with a $1,500 good bond. 31 is reset further notice with a total $2,000 SOB through the jail. 32 is going to the SAP calendar with a $2,000 good bond. 33, reset further notice with a $2,000 SOB through pretrial. 34, SAP calendar with a $500 good bond. 35 is reset further notice with a $2,000 SOB through pretrial. 36 is reset further notice with a $500 SOB through the jail. 37, reset further notice with a total $750 SOB through the jail. And on the add-on calendar, it is being reset further notice with a $1,000 SOB through pretrial.
And that's per judge too.
And it is per judge. I have it. Are there any questions, comments, or otherwise?
Does Jacarius Winters, does anybody know what happened to him?
We did him Friday. He was the add-on Friday.
Okay. Got it. Thank you.
Great. Anything else this afternoon?
And also, I got a record for the jail record from Forsyth County. He was there from, I believe, let me see the records. He was there until like April 27th for these 4 charges here at the Fulton County.
Well, no, what the paperwork says is that he was hold on the charges of theft by shoplifting misdemeanor ×2, which I don't know if that was forced charges, are charges. It says the record is silent as to that. And
Okay.
hold for another jurisdiction ×4. It also doesn't show the jurisdiction because he's also on hold for other jurisdictions.
Correct.
Nor does it show when the hold was placed on him. No additional information to let us know that, to let at least the state or anyone else know when this hold was levied and if it's beyond the 72 hours.
Okay, I'll get more details. All right.
Okay, well, y'all have a good rest of your day. I'll see you tomorrow.
Thank you very much. Bye-bye.
Judge, give me a little time to get this over to you. I have to.
Okay,
Okay.
if you will, maybe text me or call me.
I will.
As you send it to make sure that I get it back to you promptly.
No
Okay?
problem. Thank you.
Okay, thank you. I appreciate it.
Okay, bye-bye.
All right.